Yes, ma'am.
May be permitted to mention the matters for extension of interim order, Your Lordship.
End of December.
End of December.
Lordship, similar.
If these don't appear in the next week, please intimate the court because I may forget.
Lordship, similar matter for extension of interim order.
Should under the disclaimer for public land of unlawful documentation. Conversation of the act was passed. That SPM related election is of our lives. And we are challenging that we feel that as the applicant was that SPM has converted back to the SPM. We have the Latino that Latino which are but ultimately he has said that we should be. I mean, challenging that order, we have filed a petition to your lordship for justice. Vishwajit Bhaskar taken up with the matter. And that it was taken up for 50 days. And that just before the petition again mentioned that the scheme is proceeding to that. It was understood by the party, it was also undertaken by the non-decision council and all my adversary. That there are no steps to be taken on the matter will be adjourned to the guidance. I mean, the Nandi DSP has also recorded in his order that with the disposal of the hearing is disposed of. Very recently, this week, the last week, when it speaks again, it's called his own order and speaks the hearing on the level. I mean, I become non-free. Well, I was under the impression that we have mentioned we have taken steps because the hearing was done. I mean, Justice Basu was going to Miller this circuit bench just before Miller after the vacation. So now the determination change is come to Lordship that determines the matter of two fees.
Very well. On 11th, this will appear. Urgent motion.
At least one day prior because we have to.
I take public unauthorized occupants act matter on 11th. It will appear on 11th.
Very good. Very good. I'm mentioning about notice.
One of the parties means you are also.
Well, it is my landlord. I'm the landlord.
I don't mention my lord. I don't mention my lord.
Yes, sir.
I don't mention my lord. I'm an outstation lawyer. I've got a matter at 275. So it will take hardly 1 minute, my lord. Already matter has been settled by the Honorable Appeals Court and also this Honorable Court.
275.
275.
What is the matter? 275 is a hearing matter.
GST matter Ocean Freight. Already matter has been settled by the Honorable Appeals Court as well as by this Honorable Court. So it will take hardly 1 minute.
Yes, but 275 suddenly I cannot upgrade today. I cannot upgrade it today immediately.
Tomorrow, my lord.
Or what is the matter? What is the urgency? What is the urgency?
Levy of Ocean Freight on import of goods.
Urgency, what is the urgency involved to make it jump so many propositions?
Already matter has been settled by the Honorable Appeals Court or also by this Honorable Court.
I'll go in due course, yes.
Can you permit to mention, Madam Lordship, each matter all the petitioners are regular casual worker more than 30 hours. Both the parties.
Hearing matter.
Huh?
Hearing matter
Hearing
or
matter.
motion. Please give the slip. Yes.
For extension of interim order. Interim order may be expiring in the end of this month.
Yes, sir.
Lord, I mentioned two. 8 petitions for inclusion, paying for 8 years salary. One of 2012 and the other is of 2021.
Arrear salary.
8 years.
Hearing matters.
Yeah, one is hearing matter, another is motion.
Motion, I will not have determination. Hearing matter, you can give.
My lord,
Your Lordship, may we permit
Hearing
to mention
matter.
this matter. Your Lordship, this is a matter and where I preferred an appeal under 107. It was rejected on the grounds of delay. Now the urgency is that they have issued recovery notice to me. Now, my lord, I have mentioned this last week also. This matter had not come up, my lord. Kindly,
My lord.
Urgency, urgent motion.
My lord, hearing matter.
Please write your grounds.
my lord, I have stated my ground.
My lord,
Grateful, my lord.
Application for withdrawal.
hearing matter for inclusion. Already served the other.
Lordship may be permitted to mention these contempt applications. Your Lordship, the order was passed on 19th of June 2025. Your Lordship, thereafter the authority has not taken any step till date, Your Lordship.
For
Your
what?
Lordship may kindly fix any date, Your Lordship, for taking up these contempt applications.
I'll fix up a date. It's there. It's there in the list or not?
Yes, Your Lordship.
Question may I make the mention? Question, say, of hearing
Please give.
Lordship, upgradation of item number 129, Lordship.
Why, what has happened?
Lordship, notices are being issued to me. The reassessment has been initiated against a dead person, Lordship. Lordship, I was humbly beseeching your Lordship if your Lordship
Notice?
gives.
You mentioned it just now, yes. Will be heard.
My lord, upgradation mentioning, my lord. My lord, the matter was out of list, not in the list, my lord. We have mentioned and thereafter when it is appearing in the list, my lord, at serial number 351 onwards, my lord.
Yes.
My lord, upgradation has because my lord, bank attachment has been.
উনি মেনশন করেছিলেন বোধহয় আগে দিয়ে
Careful, lordship.
For upgradation, one matter, item number 591 of today's list, lordship. That is a hearing matter. I'm covered by the coordinate based order of this court, lordship.
591 mark করে রাখুন. What is the matter?
The matter is the coordinate bench directed the state government to disburse the amount, whatever the due amount of the petitioner. But in spite of that, decision the state government is withhold the money.
Why is it appearing under the heading hearing list?
Everything is complete, pleadings is complete.
No, then why, if the issue has already been covered, why were affidavits directed?
Affidavits were complete.
Why were affidavits directed? If the matter was settled, then affidavits.
That matter was settled with another petition.
We'll have to hear that. দেখে নেবেন একটু.
My lord, maybe permission to mention what matter, my lord, is the group 2 hearing, my lord. Is relating to, my lord, the school taking up the managing committee, my lord. No managing committee.
My lord, may I have your lordship's kind leave to mention for upgradation item 420, 421, the matters were disposed of by Honorable Justice Rajabashu Chaudhary, directing the appellate authority to conduct the hearing of the appeal within 12 weeks. 12 weeks have elapsed, my lord. No hearing was conducted. I have filed an application for extension of time for the hearing to be conducted, my lord. That is the only reason I've taken out applications in both the matters, 420 and
No, but if
421.
matters were disposed of, how can application be filed in a disposed of matter? It
Only
won't
for
be maintainable. We'll become functus officio.
my lord,
I'll take up applications one day.
my lord. Lordship, deeply
420,
obliged.
421.
420 and 421, yes, lord.
Very well.
Deeply obliged, my lord.
Please give. চলুন list call করুন.
My lord, this matter, while moving this writ petition, it transpires that certain mistake. Therefore, if your lordship permit, we can withdraw this writ petition, only small indulgence. Kindly give a liberty to file a fresh writ petition, only these things.
Visual, of course, I have no. But lordship, the only thing is, order is applicable.
No, that I will argue. I'm withdrawing. No, this is not. This is
Clarify.
no. How can I?
He's withdrawing it. Let him withdraw.
Let him do.
And liberty to file
Liberty
fresh.
to file afresh in accordance with law. What
Then he will argue. My lord, he has. When it
in
will.
accordance with law. If he is entitled in law, he will.
Yes.
If he is not entitled, he will not get.
Okay.
But in accordance
My lord, he will argue at length when matter will come.
Mr. Das,
No.
senior advocate.
He will argue. It is no. It is your liberty to argue.
Supreme Court judgment.
Mr. Das, learned senior advocate appearing for the petitioner,
Section 14.
submits on instructions, that where is the advocate on record?
Huh?
Where is your advocate on record?
He has given yes.
But if you are withdrawing, the advocate on record should be here because you cannot withdraw.
Huh.
Where is your advocate on record?
I will give you the letter also. Here, not with clients.
Then give it so that I have it on record.
At the moment, it is not with me. I will give you after.
Mr. Das, since you are a senior advocate, for your safety, please give that letter. You cannot withdraw it. Come tomorrow or bring that letter during recess.
Okay,
I'll
I
allow
will.
it.
I will bring the client's letter also.
Very well.
Thank you. No objection. I'm sorry.
Yes,
Just
that
I
is
think
why
I have
said
not
there'll
taken.
be difficulties later on.
Yes.
Sort it
Somebody will come up and they said,
Yes.
how
it's
I
a
have.
problem.
I'm grateful. I'm obliged.
Not today.
কপালে ছিল না আমি চেঁচালাম কপালে ছিল কপালে আমার যে কপালে আজ কপালে নেই তোমার কপালে ছিল
No, he'll be in difficulty later on because
correct.
He cannot act as an advocate on recording. Yes, that will be a problem. Yes.
My lords, there are some mistakes in the writ petition. It was filed last Monday. My lord, I'm seeking to withdraw the with liberty to file afresh, my lord. I have served notice. I had mentioned the matter. My lord had instructed me
Yes,
to
you
serve
are
notice.
the advocate on record.
Yes, my lord. My wakalatnama, along with my other colleagues' wakalatnama, is on record, my lord.
Very well.
I have written instructions also, my lord, if my lord may want
Yes,
to keep
yes,
it on
I'll
record.
keep that. That
Yes.
will be safer for you.
Yes, my lord. I have
Because
written instructions.
nothing from this side.
Yes,
It
ma'am.
is for your safety
Yes,
that you should have it.
It's on record, ma'am.
Very well. Learned advocate appearing for the petitioner submits that there are certain mistakes and omissions in the writ petition, and as such, she has been instructed. And as such, the said learned advocate has been instructed. And as such, the said learned advocate has been instructed by the writ petitioners to withdraw the writ petition with liberty to file afresh with better particulars. Full stop. In such connection, comma, a letter dated December 5, 2025, addressed to the learned advocate on record for the petitioner by the now on behalf of the petitioner number 1 has been handed up to court. Full stop. The said letter is taken on record. Full stop. You are appearing for
The income tax department, your lordship.
the respondent. Income tax authorities are represented. Full stop.
My lord, I appear for the department also. My junior is appearing.
Very well. Full stop. In view of the prayer made, comma, WPA 27575 of 2025 is dismissed as withdrawn with liberty to file afresh in accordance with law.
Grateful. My lord, I apologize. I have a sprained ankle. So
No.
for the next 2 days,
No
I
problem
will
at all.
appear online. Yes.
No problem.
Okay. Thank you. No, sir. I'm deeply obliged.
Yes, sir.
My lords, the period of dispute, my lords, is 1920. We were, my lords, providing mining support services to CCL, Central Coalfield Limited. My lord, this was crushing of coal that is mined by them and transporting them. My lords, on the crushing activity, on consideration, we were paying 18% GST. On the remaining transportation activity that we were undertaking for CCL was paying GST under reverse charge mechanism 5%. We were declaring it in our returns. They were paying 5%. My lord, DGGI investigated this entire thing because CCL had contracts with us and number of entities. DGGI investigated this and was of the view that this transportation is incidental to the crushing of coal. Therefore, this should also be taxed at 18%, not under RCM at 5%. Therefore, DGGI, my lords, there is a show cause notice, etc. My lords, important point here is, my lords, that after the DGGI investigation, CCL had already paid 5% initially, remaining 13% for all the contractors. CCL paid the amount and issued certificates to us as well as other contractors, my lords. So the entire tax being demanded in this notice has already been paid by the CCL already. My lords, this contract of ours ended with CCL in February 23 and business was closed. Investigations, etc. notices were issued, my lords, in 2024 to us. Because of our closure of business, my lords, and lesser manpower, we could not reply to the DRC 01A issued to us. Even the show cause notice, we could not participate, my lords, and order was passed after giving only one opportunity of hearing to us. My lords, we could not participate in the proceeding, my lords. My humble request is that entire tax already stands paid by the CCL in this transaction. There is no loss to the revenue, my lords. I may please be sent back to the authorities to show that then the certificate, etc., and documents that CCL has already paid it. The entire demand would get quashed by that in that process, my lords. I have enclosed the relevant certificates here also, my lords. I can show it to my lords. If my lords want, I can go back to the authorities.
Where is the order in view?
My lords, order at page 80.
80.
80, my lords.
27th August 2024.
Why did you not prefer appeal against this order?
My lords, because our business had closed down, we were not even aware of DRC 01A, 01, and because, my lords, we could not even participate in the proceedings, my lords. Because, my lords, our business has closed in 2023, my lords.
Yes, but notices must have been served on you.
Notices were issued, my lord. They were there on the portal, etc. My lords, because of the closure of business and because of the ill health of the proprietor in this matter, my lords, could not properly look into it. We could not even reply to the pre-show cause notice as well as show cause notice, my lords.
But then you will have to prefer appeal, filing an application for condonation of delay. If the appellate authority is satisfied, the appellate authority will condone delay and hear it. I'll give you that liberty.
My lords, my only request here is, my lords, that we could not even participate at the lower level, my lords. There are other issues also involved here.
No, but
natural justice
you could
violation
not
because
participate at the lower level because of your fault will not render the order bad. If you could have shown that the order has been passed in violation of principles of natural justice, notices were not given to you, notices were not served upon you, you did not have knowledge of the proceeding, then in that case, the court could have intervened. But this is a case where you had knowledge of the notice, you could not participate because of other reasons.
My lords, I did not have knowledge of the notice. They just uploaded it on my portal, my lords. I did not have knowledge of this.
Yes,
Otherwise,
but
I would have
uploaded
replied
on
to
the
it.
portal,
My
you
lords,
did
only
not look
one.
at the portal. What is your explanation? Why you could not get knowledge of the notice?
My
Where
lord,
is
because
that?
my business closed down in 23, there was substantial no staff working. Only proprietors were there. And my lord's proprietor was
So that will
in
be a
severe
ground
medical.
for you. That will be a ground for you to seek condonation with the appellate authority.
My lords, one last point, my lord, that they only gave me one opportunity of hearing. My lords, this court and number of there are high court judgments which say that they ought to give at least 3 hearings in these matters. Only giving 1 hearing and then passing the order. My lord, that per se is violation of natural justice. And my lords, number of high courts have remanded the matter back to the original authority. My lords, I'll bow down to my lords if my lords ask me to go to the appeal forum, my lords. But my only request would be that please condone the delay here, and I may be asked to produce the documents before the appellate authority or the original authority.
No, I'll condone the delay here only if there was a delay application before the appellate authority.
My lord, there is violation of natural justice, my lords.
Violation of
my lord,
natural justice
they've
would
given
have
only-
been if you would had not got notice. You had notice
My
of
lords,
the proceeding.
only in the show cause notice they mentioned, please furnish reply by 26 June and come up for hearing on 2nd July. There was no further notice of hearing given to me.
No, although you did not furnish any reply also to the show cause.
My lords, I could not have furnished. They just uploaded on the portal. My lords, I was not having the knowledge, etc. They ought to have issued, my lord, 3 notices.
No, it's not like that. Your lordship 75, if your lordship kindly sees 75.5, which says is very specifically that
Page?
yes, 75.5, that is the
Section.
section. This is the law, your lordship.
Yes.
May I base it?
Second one.
75.5, yes.
5. Section 75.5. The proper officer shall, if sufficient cause is shown by the person chargeable with tax, grant time to the said person and adjourn the hearing for the reasons to be recorded in writing, provided that no such adjournment shall be granted for more than 3 times. My learned friend is confusing that they have to ask for adjournment.
Allow me to place one judgment of this only, I could only, my lords, which has remanded the matter back for this reason only.
Show me.
My lord, page number 11. My lord, it's a small order, 2-page order only. May I read, my lords? My lord, second page is all the relevant points. Page number 12.
Value added.
Yes.
My lord, even the next page, my lord, here also, my lord, because he could not furnish the reply because of his medical condition.
This is in respect of an individual.
My lord, I am also.
Individual was suffering from carcinoma. You
My lord,
are a company.
My lord, not company. I am JV, RSSG, OT. RSSG is also proprietorship from my lords. OG is also a small transporter.
They are amalgam of 2 companies, isn't it?
No, my lords, 2 partnerships, two individuals. RSSG is a my lord's proprietorship of Saurav Kumar Gupta, and OT is Om Transport, my lord. Both small time people, my lords. We are not big companies.
Then
Yeah, provide-
how have you filed the writ petition in the name of a JV then?
My lord, this because this contract was awarded in the name of JV only.
Then the JV is not a juristic entity.
And JV is the juristic entity, my lords.
How? If the constituents are not juristic entities, how will the JV be a juristic entity? You have to implead one of the constituents then as a party.
My lords, JV, RSSG, OT was granted the contract. Order is the name of RSSG, OT only.
Contract, it may have been granted, but has it been registered as a juristic entity, as a company or a partnership?
My lord,
The JV.
GST registration is the name of RSSG, OT
GST
only.
registration will not give you personality, sir. For personality to have, for you to have personality, it should either be incorporated as a company or an association of persons also incorporated. Unincorporated and unregistered societies may not maintain writ petitions. Look up the law on the subject.
Yes, your lordship.
Partnership is also a compendium name or the 30 CPC. So compendium name, description of parties who form the partnership. Mr. Day and I had tough time in doing all these things while at the civil bar. Order 30 corporation.
If my lord want, I can add the one of the constituents as the petitioner.
You should, because the writ petition is otherwise not maintainable.
I'll add, my lords. Please give me a liberty. I'll add this, my lords. Otherwise, my lords.
As prayed for by the learned advocate appearing for the petitioner, liberty is granted to the petitioner to amend the
Public Premises Unauthorized Occupancy Act 62 invoked, and order has been passed by the SDO. When challenging the said order, I prefer an appeal before the collector, that is DM. Well, that has not been decided as yet.
Our party is concerned, my lord.
You
The
are-
law is a very specific, my lord.
you are
I appear on behalf of the state, my lord. Law is the very specific. If the order is passed in
No, but if
exercise
he
of
has- if
section,
he-
in exercise of
if-
section 2,
if
subsection
he,
1
if
B,
he has preferred appeal,
they have prepared appeal, but it was preferred before the wrong forum. If the order is passed, section 7 says,
yes, before whom have
Check.
you preferred appeal?
he preferred the appeal to the district magistrate.
Absolutely.
Why wrong
No,
forum?
my lord, kindly go through the
Dara,
section
open
7.
it,
That
Yes.
there is section 7, it's a very specific.
Yes.
Where it clearly states if the order is passed in exercise of section 2, subsection 1, clause B, in that case, the appeal lies to the collector.
Absolutely.
But here the order is passed. If you, your lordship, have a glance at page 21,
Page 21.
page 21, the order sheet, where the order is passed in exercise of section 3, subsection 1.
No.
And this order is passed pursuant to the directions of the Honorable High Court.
Subdivisional officer.
Yes, don't dilute the issue, sir.
Section 2(1)(b),
Yes,
either district magistrate or subdivisional magistrate.
but Kailash, very.
Well, at subdivisional magistrate passed an order. The authority to
The
whom
order
it,
is always under 2(1)(b).
yes,
The proceeding may be under
But
section 3.
under section 3, subsection 1, the
That
word
is,
oh.
you see section 3. Please read section 3. Order has to be under this. Order is under 2(1)(b) only.
Yes,
This is not the wrong forum. It is the right forum.
absolutely.
Absolutely right forum.
And 7, there are
The
two
appeal is
parts,
pending. Where is your appeal?
my lord. Next page.
You cannot render the appeal infructuous. Let it be heard.
Page
Let it-
23.
Page 23.
This, my lord, there are prayers including the interim order in the appeal. Therefore, if it is decided, thereafter, whatever the consequences, that will follow.
And you have filed the appeal when?
My lord, this was filed on কত তারিখে? June. Date
And how
nine.
where do I find that it has been filed? From which document?
এটা তো হাইকোর্টের seal.
sorry, here,
Yes.
Sir, what is your instruction? When was the appeal filed?
well, I don't have any instructions, my lord. So far,
Right.
when the appeal was filed, I don't have any instruction. I sought for the instruction, but from the verification page, my lord, it appears that I signed this
So what is
verification
it?
on the
Yes,
last
sir.
page, that is page
Then
32.
appeal
It
filed
Yes,
appears
in April
April
2025 only,
2025.
but this is blank. When
This
was
is
the appeal
blank.
filed?
Appeal file, my lord, I cannot say, but number is
No, you
there.
have to tell me which
Well,
number.
he has
When-
filed the appeal.
Appeal number,
When was it filed?
my lord, June. I have stated so, but
It's a written as a April, now he is saying that.
কোথায়
June.
লেখা?
It's a very-
Order under challenge was passed on April 5.
True.
Order was passed in the month of April.
3rd April 2025.
Where have you written that?
My lord.
Page 21, the order and the.
No.
The rejection order, my lord,
Where have you written? When did you file the appeal?
কবে ফাইল করেছো ডেট জানো তুমি? কোথায় লেখা আছে সেটা?
The appeal appears to have been filed in April from page 32.
Yes.
Yes.
So why are you saying June?
an order was passed on 3rd day of April 2025.
So take instructions properly. Come back. Sir, you also take instructions. When was the appeal filed?
Yes, sir.
Likhun.
Instruction for the appeal.
My lord,
The petitioners. Come back with proper instructions.
Lord.
both of you. Yes. 2 PM করে দিন।
will come before your lordship against the non-application of mind at the time of disposing of the appeal petition by the respondent number 2, my lord. My lord, the fact of the case, my lord, lordship comes down to, my lord, page number 19, my lord. 19. Yes. This is the ASMT 10, my lord. That is a scrutiny of the returns, my lord. And 20 is, well, 20 is tax short paid on outward supply, tax short paid on RCM, ITC found reversible. Well, 8,948 and 8,948. My lord, herein after, my lord, page number 21, lordship comes, my lord, which is the continuation of the ASMT 10 notice, my lord. 21, my lord. My lord, on the top, my lord, liability as per GST 1 is 23 lakhs, my lord. Herein after, my lord, IC, 1C, 23 lakhs 26,000, my lord, same as to liability under GST 1. Liability under GST 9. Well, there are, in the meantime, my lord, what I want to submit is, there are 2 statements and 2 returns, my lord. Statement under section 37 is the outward supply statement, my lord, which I upload in the portal, GSTR 1. Statement, my lord, herein after, my lord, 2A is generated when the other side, my supplier, files his GSTR 1. It is a statement in GSTR 2A and 2B, my lord. Now it is 2B, which is my ITC, which will be available to me, my lord. Herein after, my lord, after I match this GSTR 1 and GSTR 2B or 2A, my lord, I file a return in 3B, my lord, which is under section 39. Herein after, my lord, under section 44, an annual return is to be filed, my lord. The last date is 31st of December, my lord, of that particular year, my lord. These are the 4 returns. Now, my lord, my annual return as per 1D is showing a turnover tax of 20 lakhs, my lord. Whereas, my lord, my 3B is 16 lakh 78,098, my lord. 3B for the total year. Herein after, my lord, I make my amendment. I file the annual return at the end of the year, my lord. It is not considered. The higher figure, which is 23 lakhs, is considered. With that, minus the 3B figure, and 6 lakhs is demanded from me, my lord. My lord, all the herein after, my lord, all the notices, my lord, I will not trouble your lordship, as because no reply was made against these notices, my lord, I went for an appeal. Now, my appellate authority, my lord, the order is in page number, my lord, 87, my lord.
87. Yes. My lord, the point of contention, my lord, from the top, not from the top, my lord, from the middle, my lord, present for the applicant, my lord, lordship has seen, my lord. The instant application has been filed electronically under section 100 days. This for the of the act by the applicant challenging this. My lord, the dispute is tax for rupees 9,250 GST, IGST, 657,709 CGST and SGST, interest and penalty, my lord. Herein after, lordship comes down to, my lord, page number 90, my lord. Well, there are 2 boxes, my lord. My lord, after the box, my lord, as per audited final accounts dated 31/1/2022, total turnover of sales is rupees 82683673.58. 8 crore 26 lakhs, which matches with the taxable value declared in 9 and 9C, my lord. Annual return matches, my lord. The learned heir for the appellant submits that one of the main reasons for discrepancy of taxable value and outward tax with respect to GST 1 and 3B is due to fact that the GST 1 filed for the period 2021, the total value of January, February, and March were declared by mistake, my lord. What has happened, my lord? The March figure was also including the January and February figure, my lord. And he's admitting and giving relief to that, my lord. Was declared by mistake instead of the value pertaining to March 21 only, that is the taxable value and outward tax already declared in GST 1 for January and February 21 were again added to declared in GST 1 of March 2021.
The learned heir further submits that the amendment with respect to above mistake has been made in GST 1 filed for the period April 21 by DRN number this. In order to verify, my lord, he verifies it, my lord. If lordship comes down to the box at the bottom, my lord, GST 1, my lord, March 2021, my lord, it is 15 my lord, 15 lakhs 32,000, my lord, 1 crore 53 lakhs, my lord. And at the next, my lord, 3B is 5 lakhs, 50 lakhs, my lord, 43, my lord. He admits, my lord, in the next paragraph, my lord, 91. Now, as seen from the above data, the taxable value on outward tax as declared in GST 1 of January and February 21 matches with the value corresponding to GST 3B of January and February 2021. And that the total taxable value and outward tax as declared in 3B for January, February, and March 21 taken together matches with the corresponding value declared in GST 1 filed for March 2021. Being so, it is evident from the BO portal that taxable value of 10279022 involving outward supply of 257060 and CGST and SGST each has been declared in excess of GST. Malad, my demand of mismatch has been reduced from 6 lakhs to 3 lakhs odd now. Now coming down to the thus.
No, where do we get that it has been reduced from 6 to 2?
From this paragraph, the top, third line from the top, fourth line, being so, it is evident from the BO portal that taxable value of 10279022.12 involving outward tax of rupees 257060 and CGST this has been declared in excess filed in the file for the period March 2021. However, examining the books and accounts and relevant document of the applicant is warranted in order to verify the actual turnover and outward taxable tax payable. Upon perusal of the sales register and outward supply register, sales CGST, SGST, thus, after careful perusal of the books and accounts, including the audited accounts, the actual taxable turnover of appellant and the outward taxable tax payable thereon and the turnover declared in 3B and tax paid thereon are found as follows, my lord. Here, the fourth column, my lord. CGST 2067 883.884.
Yes.
3B is 16780998. In fact, if lordship comes down to once, takes trouble to come down to page number 21, it will be clear.
Page 21. Yes, page 21.
The last column, one
tax short paid.
Short paid.
Yes.
6,48,000,
Yes.
And in page number 91, this is coming to tax short paid is coming to 3,91,705.
Yes.
Now, now the interesting part is in this column, he is considering the books and accounts figure, for calculation,
He is calculating
the books and accounts figure, books of account, 2069,883.84. This is a tax amount. Lordship once, herein after, comes down to, page number 60.
60. Page 60. Page 60.
My lord, 60 is my detail of outward supply in GST 1 for the period April 2020, April 2021, 1 month. My lord, in page number 61, the total taxable value is 16451431.42.
Yes.
My lord, herein after lordship invoice value, total invoice value. Now lordship comes down to page number 65, my lord.
Page 65.
On the left hand side, my lord, 2021 period April 3B return.
Yes.
My lord, this because of certain portal mistake, my lord, it was filed nil, my lord. There were technical glitches in the portal. My lord, it is this figure in page number appearing in page number 61. The taxable value is to be automatically imported into the 3B returns, my lord. Somehow it went unnoticed, my lord. My lord, hereinafter, my lord, lordship comes down to 67, my lord.
And this form GSTR1 was filed by you.
Yes. But it is from the portal, my lord. It is from the portal. I have downloaded this from the portal itself.
Yes, and GSTR3B is the annual one.
Annual one. No, 3B is not the annual. 9 is the annual one. 3B is the return.
Return.
Quarterly. No, monthly return, quarterly return, depending upon the dealers. Page number 61, my lord.
This is also filed.
Yes.
Or this is auto-populated,
Yes.
no file.
Yes. My lord, here page number 67, my lord.
Page 67.
My lord, from the bottom, my lord, fourth line is system generated summary for reference, my lord. This is from their portal, my lord. From the top, my lord.
67.
From the top, my lord.
Yes.
Fourth line, my lord. System generated summary, my lord. But there is appearing, my lord, GST1, form GST1
Yes.
at the top.
Yes.
Thereafter, my lord, fourth line is system generated summary. My lord,
Yes.
I have downloaded it from their portal, my lord, itself. And on the left hand side, financial year 2021, my lord.
Yes.
My lord. Now, my lord, as per this, my lord, page number 68 is my total invoice value is 9 crore 76 lakhs, my lord.
Total in
68, my lord.
76.
Paragraph number 7.
Yes.
9 crore 78, 9 crore 76 lakhs. Hereinafter, my lord, lordship comes down to, my lord, page number 72.
This GSTR1 IFF is for what?
My lord, it is for the full period. For the total 2021, my lord. For the 12 months, my lord.
So sort of annual.
Sort of, no, it is not annual, my lord. Summary, what I have filed, my lord, in the portal, my lord, for each and every year. After the year is completed, my lord, I can generate this.
No, for each and every year means what? For many years.
No, my lord. Each year, my lord, they will be separate with GST.
So this
for
is
this
sort
period,
of annual only. It is yearly.
Yearly. For each year, my lord, one for the 12 months, my lord, one IFF, GST1 IFF will be
So it
generated.
is annual. In that
Yes,
sense,
my lord,
it
it can
is
be
annual.
said. It can be said.
IFF full form is invoice furnishing facility, your lordship.
So that is why this GSTR1 and this GSTR1 stroke IFF, the figures don't match. This is for monthly, quarterly. Page 61.
Number 61.
Total invoice value here was 16451,431. Here it is
Yes.
976.
It is. This is 61 is for the 1 month, my lord. April.
This is monthly and this is
yearly. My lord, 67, my lord, on the left hand side, my lord, financial year 2021 is been mentioned, my lord. 67 on the left hand side, my lord. Now, my lord.
Right side.
Right side, my lord.
Right side top.
Yes, my lord. Right side. But hereinafter, lordship comes down to page number 72, my lord.
72.
My lord, annual return, but annual system generated annual summary of 3B, my lord. My lord, on page 3.1, my lord, outward taxable supplies 67015,643 total taxable value. Hereinafter, my lord, 76.
76.
My lord, which is the annual return 9. My lord, here, my lord, the total outward detail of outward supply, my lord, after 3D, my lord, after 3D, my lord, from the top, my lord, I think 7th column, my lord, detail of outward and inward supply, my lord, and the column 4A, my lord, supply made to unregistered person is 826, 83, 673, my lord.
Yes.
My lord, if 3B, page number 72 is considered, then, my lord, 6 crore 70 lakhs was declared in 3B, my lord. And here I have declared 8 crore 26 lakhs, my lord. This 2 crore something, my lord, addition, my lord. My lord, according to 9, my lord, tax has to be discharged, my lord. I have discharged my tax, my lord. Now, if, my lord, page number 91 is considered, my lord.
Page 91.
Well, just a moment, my lord. My lord, 91 along with 76, my lord.
91 along with
76.
Yes.
My lord, the column where 8 crore 26 lakhs has been displayed, my lord. My lord, 4A.
Yes.
My lord, just beside that, CG, central tax and state tax, 2067 799.25. And my lord, lordship comes down to 91, my lord.
Yes.
That middle column, my lord. That middle box, my lord. Where the books and accounts figure has been taken, my lord. 2069 883.84, my lord.
Yes.
He is considering this calculation, my lord, being satisfied. He is considering this calculation, my lord. And in 9, my lord, I have already discharged my liability, my lord. Apparent from 76, my lord, 2069 799.25. Also, you got it, my lord.
Yes, if it is matched with
Well,
GST 9,
well, some difference is over there. Some difference definitely is over there.
instead of 799,
Well, 100 rupees. 899. The difference of 100 rupees. But
So he has
now
not
what he has
considered-
done, my lord. Now what he has done. The above detailed tax paid pertains to the period 20, April 20 as interest, my lord. This was the learned here submits that the GST 3B for April 20 was the file declaring thereon outward tax payable at 391,700 as CGST and SGST each and ITC available of this each. However, as per the learned heir's statement, none of the above declared outward tax as well as ITC available were found reflected in the said 3B due to technical glitch. In support of his statement, he has produced copy of grievances, mailed this, raised help as this. Now, careful perusal of the GST 3B file for the period 2020 is made in BO portal. It is found that the said 3B has been filed on this. The taxable turnover, outward tax payable as well as ITC available was found to be nil. However, it is to be noted that the late fee paid by the appellant referred number this, dated this, of rupees this. Hereinafter, my lord, further it is hard to understand the appellate took more than 4 years to. My lord, I might have taken 4 years, my lord. But where is the difference in discharging the tax? It is only of 100 rupees. The difference only is of 100 rupees. My lord, for his concern, my lord, in the box, my lord, from the bottom, my lord, the box, that 20 lakhs figure has been taken. And that 20 lakhs figure has been discharged in my 9, my lord. So there is no difference, my lord. Only a difference of 100 rupees.
how has he considered your GSTR 9?
My lord, he has not considered. He has not considered. Only as regards to the difference of April, my lord, the difference of April, first difference, my lord, he has considered 3B for April. In fact, my lord, 3B for the whole year, my lord, 3B for the whole year has been considered, but not the annual return.
Where is 3B for the whole year?
My lord, 3B for the whole year is in page number, my lord, 72, my lord.
So where has it been considered?
My lord, this figure of 1678,098, my lord, in page number 72.
Yes, 72.
2.
Yes.
My lord, serial number 3.1A, my lord.
3.18.
The tax amount is, my lord, 1678,098.49.
Yes.
My lord, lordship comes down to page number 91.
Page 91.
But that box,
This,
that pertinent box, my lord,
middle
3B, 1678,091.49. Well, after filing the 3B, I filed the annual return in 9.
And there you have discharged it.
I have discharged.
If that had been considered, this 3,91,000 would not have come.
Not.
Yes, Mr. Sanya. Or Mr. Chakraborty.
Before going into the merits of the matter, so there has to be something in the writ petition, pleading wise, to indicate this is the grounds. Well, let my learned friend show. The difficulty is whenever we seek instruction, we do not get this because nothing is pleaded in the writ petition. Not a single ground, there is non-consideration of annual return.
What is there in the writ petition?
When nothing is there, kindly see the pleadings. In
My lord, technical glitch has been pleaded, my lord.
only the technical glitch. The entire argument, my lord,
Is non-consideration of GSTR 9.
that I do not need to quote Bharat Singh or anything subsequent of Justice Deepak's judgment. A third case is being made out, my lord. I do not see that ground also, my lord, in the petition also, in the appeal petition. My lord, see the grounds as recorded. If I grounds 89, my lord, these are the grounds. Ground 17, he has said in a GSTR could prejudice.
My lord, comes down to my lord, page number 11, my lord. My ground 8, my lord. My lord, from the top, from the bottom, my lord, third line. The petitioner duly
Yes,
rectified
yes.
the said non.
Ground 8 is there. Petitioner rectified the said non-reflection while filing its
My
annual
lord,
return.
this is a factual finding. Not a ground has to be legal. My lord, this
Very well, they have taken this.
but this is not there before the appellate authority. Then I go back
before the appellate authority. What has happened? So show me the appeal.
My lord, appeal is in number, my lord, page number 54, my lord.
Yes, page 89, ground 7, Mr. Chakravarti.
Well, 7 I said that is but can that is my lord, subject to correction, my lord, that is nothing. My lord.
No, but this is sufficient because he is supposed to apply the mind to the matter. Why, if he has paid taxes, why will he doubly pay?
My lord,
He
can
ought to have
remand back,
noticed.
my lord, has to be
Yes, I'll have to
considered.
remand it. I cannot decide it here. He will have to check it again. He'll have to check it again. लिखे नहीं
I am for the question. Here, my lord, I am challenging, my lord, the ex parte appellate order, ex parte adjudication order, and show cause notice. In the appellate order, my lord, what happened? They issued the notice of hearing rightly. I prayed adjournment. They issued notice of adjournment. Thereafter, notice of adjournment. But, my lord, on 2 notice of adjournment we missed. In as communicated in the portal, we missed, my lord. Thereafter, passed the order after much later, after 1 month. But in the meantime, my lord, one more adjournment could have granted, my lord, as section says, my lord, that 3 adjournment. And, my lord, importantly, the grounds of appeal not considered. This is violation of subsection 12 of section 107. This is the appellate portion. In the adjudication portion, my lord, show cause notice issued. In the show cause notice column, written personal hearing not applicable. We submitted reply in due time. But while passing the order, they much time after 1 or 2, then 1.5 months passed the order. In between, they could have easily granted the personal hearing. But law says that if I pray or not pray, my lord, the section 75, section 4, and our division been held, then a personal hearing has to be given when adverse decision. And, my lord, while passing the order, there is another violation. Section 75, subsection 6, read with section 73, subsection 9. Because, my lord, that reply, the subsection 6 of 75 says that the proper officer shall set out the fact of the case and reason with decision. That was not given, my lord. May I, my
Yes,
lord,
Mr.
first?
Chakraborty, short point.
Very short point,
We
my
have
lord.
not given him hearing in any of these stages.
My humble understanding, my lord, maybe to the adjudication. And on merit, my lord, in that, very good.
Merit, I will not go into.
Only 11,000 tax is payable, nothing
That
best
you
are payable.
satisfy first. You
Yes,
have
my lord.
not been heard. I will not be the adjudicating authority.
Yes, yes, my lord.
No instructions. You need time to take instruction or ready?
No. But if no opportunity is given, man, I have to only check it up whether any emails were sent or not. But
I've checked the portal and I may show your lordship. If you kindly permit me, only 1 or 2 minutes. I may show my.
If you are ready, Mr. Chakraborty, we can take up. Or you want time?
take time.
Let him come back. Mostly this is adjournment. Mr. Chakraborty heard Mr.
Maybe, my lord, same heading.
থাকবে
Same heading, my lord.
Under the same heading লিখে দিন.
One matter goes down, my lord. I'm grateful.
This is an outcome of national justice issue. So there was a pre-show cause notice intimation
My lord,
that was
in
given.
this matter, Mr. Bhaskar Prasad Banerjee is appealing, but he engaged in the other court.
Pass over.
Bhaskar
Passing
Prasad
it over.
No, pass over, no, my lord, make it on Wednesday.
Tell me, Mr.
I have no objection.
An accommodation is prayed for on behalf of the respondent. Full stop.
One indulgence.
Yes.
4 hearing opportunities have already been given. So there's an urgency in this matter.
Yes.
Yes, if it can be kept at the top of the list.
It is appearing as an urgent motion under the same heading.
Under the same heading. Wait.
My lord, item number 9, I'm appearing for the petitioner in this matter, my lord. My lord, may I seek liberty to appear virtually, my lord?
Yes,
This is in respect, my lord, this is in respect of an appeal which was preferred by me and it was dismissed. The appeal is against an order of demand in by the senior joint commissioner. My lord, the issue principally is whether my appeal was within time and whether condonation of delay under section 107 subsection 4 is to be construed in terms of the statute itself, the prescribed period, or can it be expanded? My lord, my lord, kindly comes to page 59, that is the impugned order. I have not been granted an opportunity, and prior to the appeal, I have also made out sufficient cause to explain the delay. Without considering this and relying on four judgments which were
What is
not.
the extent of your delay, Mr. Das?
My lord, the extent of my delay is approximately 6-7 months beyond the period, because my lord, I am a company which is principally in Delhi. My lord, if I may indicate the facts briefly, my lord, the company petitioner
show me your
was
application
formed
for
as a.
condonation. Mr. Das, show me your application for
Yes, my
condonation
lord.
of delay.
My lord. My lord. My lord, I filed an appeal. There was no per se separate application for condonation, but my lord will kindly see page 57 is my request for condonation. It is in the nature of a letter, my lord. My lord, the ground that I have taken is it's a company which is formed for the purpose of construction of a road and for operation of toll in between Calcutta and Haldia. My lord, after the construction of the road, the operation of the company has completely shifted to Delhi. All its officers are in New Delhi, and when this particular demand was raised, it was raised after a period of more than 2-3 years. So I had to get this communication and documents from New Delhi, and then thereafter approach this court and approach the
No,
commissioner
but
and file the appeal,
communication
which
is
was the
done.
cause for delay.
Communication is done online. Must have been done by the through the portal.
Well, I have received letters, but my files are in New Delhi. I had to trace those files
Then,
back, and there were only there rather.
Mr. Das, pay some costs. That is the usual thing. Pay costs.
My lord, I would request that since this is the and my lord, one more issue: the toll collection is an exempted demand. So, in so far as the toll collection is an exempted, I would only request minimal cost be paid, my lord, because this is an organization. It's a central government organization. The body, all its officers were in New Delhi at that point. My lord, I will not come in the way if my lord imposes cost, but I would
Yes,
only
yes.
request minimal cost be or nominal cost be imposed, my lord.
Very well.
Lordship, it has not been served, right? In the GP office.
Oh, it has not been served.
This is our GP office in the department.
Serve again. It is
Well, I
submitted
shall
by.
serve again.
It is submitted by. You are not appearing, Mr. Sanyal, in this.
If they have not served, your Lordship.
Very well. None appears. Affidavit of service filed today be kept on record. None appears for the respondents. Full stop. The petitioner shall serve a copy of the writ petition upon the office of the learned government pleader. Acha. Since Mr. Chakraborty, Mr. Tanay Chakraborty, who usually appears for the respondent GST authority, state GST authorities, is present in court, comma, a copy of আগেটা লিখেছেন তো none appears for the respondent, a copy of the writ petition may be served upon Mr. Chakraborty full stop. List this matter once again
In this case,
My lord, in this matter also, Mr. Bhaskar Banerjee appearing.
he is in some other court. If Passover, I am okay. Otherwise,
Passover, he could not come.
then tomorrow, not today only, Lord.
Not today.
Yes.
Yeah. But I appear for the petitions. Your Lordships, I am against an adjudication order which was passed on 24/24, April 24, and recovery of the entire tax interest penalty has been done in October 25 on the ground that we came to the aware of the order only on the recovery being done from our bank accounts, and there was no personal hearing given. 75/4 in the show cause, it was NA. We had participated in the scrutiny stage. ASMT 10 was issued. We had filed our reply and we had reversed 62 lakh, and we had given proof of that. After that, Lordship, everything was uploaded in the additional notice tabs because it was prior to January 23. Prior to January 23, 2024, when it was under additional notices tab, therefore it was missed. And it is a JV company, Lordships. It is a JV company between Taxmaco and one other firm for construction of road. So, Lordships, when it is a JV, the accountant who was looking after was not fully aware. He could not inform, and in the meantime, entire tax interest penalty has been recovered. But 75.
Because also you could not reply.
No, Lordships. Lordship, my only humble plea, Lordship, they have recovered.
Yes, Mr. Chakravarti.
But I do not know whether a joint venture company has come before my head.
Yes, it's a company.
Joint venture both. No, it's not a company.
It's a company.
No, one company has come. So both companies have made a joint venture subject to correction.
But they are represented by the chief finance officer.
One. I'm saying that there are two. It's like a partnership. I don't know. It's an American term of a partnership.
The chief finance officer is of the joint venture only.
Of the joint venture. Whether it was sent or not, we have to check. Because he's right for DRC 03, he paid. He had reversed certain payments. So I have to check it up.
Page 64, Lordships, kindly says show cause NA, and after that, the order does not record that
also is
additional notice.
Oh, no, that is what additional. That's why I did not open my mouth. I'll come back with instruction on this.
When?
But he is not placing other points.
No, 168 I am not placing. No point placing 168 Lordships. I am just wanting a remand and the recovery which has been done. Lordships may kindly fix 4 weeks time to adjudicate. We will participate. Till that time, let the amount be with them. I am not asking a refund of the amount subject to outcome of the adjudication.
Yes.
It can be discussed. I've attached screenshot of additional notices also. It is a part of it.
inverted comma closed, tab, full stop, paragraph. It is na paragraph na diya, and as such, the petitioner was unaware of issuance of the said notices and passing of the adjudication order. Full stop. Paragraph. The petitioner has contended that the petitioner for the first time became aware of such order being passed upon a notice of recovery being served upon the petitioner when Mr.
Lordship, first, my credit ledger, it was recovered from my cash ledger on
Upon-
31/7/25.
upon na served upon the petitioner na kore, first became aware upon recovery is being made from the petitioner's electronic ledger, electronic cash ledger on July 31, 2025.
And then Lordship, page 77, the attachment notice, the bank
And-
recovery notice.
And issuance of a recovery notice in form DRC 13. This DRC 13 was served through mail.
It was not served to me, it was given to bank. Bank gave me.
Which DRC 13, which was handed over to the petitioner by the petitioner's bank. Full stop. Paragraph. What was this matter?
This matter was that whether they have recovery notice has been issued in their name, whether they have received the notice or not. Your Lordship, I have received instruction from, if I can please, what is the answer? Recovery case was done. It was generated and it was sent to the address at 5 Kushtia Road, 4th floor, Kolkata, which was their original address, which is mentioned in the. Then, Your Lordship, after that inquiry report by a visiting officer, place of business at Kushtia Road could not be traced out. In the local inquiry, they come to know that it's running his business through B.A. and Brothers.
You file a report in the form of an affidavit annexing all this. That will be better. Then we can dispose this off. Likhe heard learned advocates appearing for the respective parties. Full stop.
Is unwell today and unable to appear for the matter today. So I am humbly praying for the adjournment for the day.
Not today or not this week?
Not today.
Not today.
Yeah.
Not today. Next. Where's the other side?
We saw the junior, not the senior. She was there sometime back, 5 minutes back. Maybe. Here she is.
Yes, Mr.
My lord, in this matter laid by Mr. Uday Shankar Bhattacharya, he is on his legs before court number 1, my lord.
What, Passover? Not today. What?
My lord can fix it 2 p.m.
2 p.m. 2 p.m.
Grateful, Your Lordship.
Well, I am a petitioner. Well, here,
My lord, I am told by my learned friend that another matter has been fixed at 2 p.m.
Yes, it has been.
Judgment.
No. One is judgment, another has been passed over, will be taken up at 2 p.m.
So I
That
will
is
be
before you. Yours will be after that.
much. 15 minutes.
the last occasion, my lord, leave was granted to make the customs as party, my lord.
Yes.
That I made, my lord. We tried to, my lord, serve upon the customs authority, my lord. It has been, my lord, unserved as refused, my lord.
Customs refused.
No, the matter may be remanded back because, my lord, it's a non-speaking order, my lord. Your lordship will kindly consider. Kindly consider the appellate order, my lord. Page 110, my lord.
Yes.
Well, what happened, my lord? Petitioner made import of the goods, my lord, upon payment of the IGST, my lord. Well, since the credit on account of
Yes,
the IGST,
they were supposed to be made party because
the
IGST was an issue and
it has to be
customs would have-
verified by the customs, my lord.
Yes.
So, my lord, let the authority, my lord, the concerned state authority wrote a letter to, my lord, the customs authority whether this credit or on account of the IGST has been made or not, my lord. They will verify and thereafter give the report to the authority.
Mr. They usually appears for customs authorities. Why didn't you contact him?
I will contact him.
It can be resolved then.
Or Mr. Bhanja.
Yes, anybody.
Yes.
Because again, going back to the appellate authority, client will necessarily suffer unnecessarily.
No, because we have produced the documentary evidences, my lord, showing that the IGST was paid. Because the bank statement we have produced, my lord, and the bill of entry where the credit is, my lord, reflected, it has also been produced before the authority.
Yes, 6.3 was the point of contention because the order was somewhat inconsistent with the observation.
Finding, yes.
These get customs has to doubt their
Well, in case of the import, my lord, the customs did not release, my lord, the goods without payment of the IGST or the customs duty. My lord.
Because what is not reflected, that has been deducted.
Yes.
It means the other was reflected. If the other was reflected, it should have been the other way around. If you see, they say 23 lakh and odd was not reflected. If it was not reflected, then the immediate presumption will be it was not paid. So credit of that will not be given. Balance credit ought to have been given. So he has deducted that and he has given him credit for that which was not
reflected.
And he has not given him credit for something which presumably appears to have been reflected because that is the usual understanding. Huh? The order is clumsy. Yes. So he'll consider this aspect again. What
Yes.
else?
Well, in case if it is needed, my lord, they will write a letter to the customs authority whether the amount has been paid. Merely, my lord, in the portal, there is no reflection, so I am disallowed. Without taking any, my lord, effort
That
to.
is why customs, it would have been better if if customs had appeared here.
Because portal is, that's why, because the portal.
Because they will go by the portal only.
Portal only. They have to
No,
tally with the portal.
that is not the law, my lord. By the portal, they have to allow. Because I am producing alternative, all the evidences, my lord. Bill of entry shows that I have paid the IGST. Bank statement shows that I have paid the IGST.
What is the law? Show me that. Then we can sort it out here. Since we have added them as parties and they don't appear.
But kindly come to page 4 of my writ petition.
Page 4 of your writ petition?
Yes.
Yes.
Lord, I have, my lord, in a tabular form, the relevant sections and the provision I have, my lord, brief. Section 2, subsection 10, my lord, defines the import of goods. What is import of goods? Now, my lord, kindly come to section 5(1) of the IGS. Next page, my lord, page 5. It says, my lord, provided that the integrated tax on goods other than the goods as may be notified by the government on the recommendation of the council imported into India shall be levied and collected in accordance with the provisions of the section 3 of the Customs Tariff Act of on the value as determined under the said act at the point when the duties of customs are levied on the said goods under section 12 of the Customs Act 1962. So when the goods are imported, my lord, bill of entry is prepared, and in the bill of entry, my lord, on the basis of the self-assessment, I have to show, my lord, what is the duty payable and the IGST payable. And I will show you to your lord, bill of entry has been annexed, my lord, with this petition. Now I have to pay IGST before, my lords, getting the goods released from the customs authority in advance. It is not that I will get the release, get the goods released, and thereafter I have to pay money. Customs will not release the goods until under the IGST and the customs duty, as per my self-assessment, is paid or not. Now, kindly see section 3, subsection 7 of the Customs Tariff Act.
Yes.
Any article which is imported into India shall in addition be liable to integrated tax at such rate not exceeding 40% as is leviable under section 5 of the
Yes,
Integrated
read that.
Goods and Services Tax. Now, section 2, subsection 62, clause A defines about the input tax. What is input tax, my lord? In relation to a registered person means the central tax, state tax, integrated tax, union charged on any supply of goods, the integrated goods and services tax charged on import of the goods. So, my lord, input tax is the integrated tax which is charged on import of the goods. So, I can take the credit of that. Now, my lord, kindly see what is input tax credit. Well, what is input tax? That is the input tax credit. Kindly come to subsection 16(1). What is the conditions, my lord, for availing the ITC? Every registered person shall, subject to such conditions and restrictions as may be prescribed and in the manner specified in section 49, be entitled to take credit of the input tax charged on any supply of goods or services of both to him which are used or intended to be used in the course of or in furtherance of the business, and the said amount shall be credited to the electronic credit ledger of the such person. So I have claimed, and as per my 3B, when I claim, my lord, it has been reflected in my electronic credit ledger. Now, clause 20, clause 1 of the section 20 of the IGST Act, my lord, says, subject to the provisions of the Act and the rules made thereunder, the provision of the central goods and services relating to the input tax shall mutatis mutandis, because it is the IGST, my lord. The provisions which has been laid down under section 16 will be applicable to mutatis mutandis. Now, my lord, kindly see, I claim the ITC on the basis of, my lord, IGST which has been paid at the time of the import of the goods in terms of the section 16(1). Now, my lord, that ITC was not reflected in the GSTR 2A or 2B, my lord. Therefore, there was a mismatch in the claim of ITC vis-a-vis, my lord, the GSTR 2A. Just because there was a difference, they disallowed my claim of ITC. Now, my lord, gone. The CBIC has issued a circular, my lord, in this regard, that for the purpose of claim of IGST on account of the import of the goods, on the ground of mismatch in the claim of this between the GSTR 3B and GSTR 2A, the authority should not disallow the claim of ITC. Well, kindly consider, I have annexed a copy of the circular, page 114.
114.
114.
Yes.
The initial circular was issued by the CBIC, my lord, circular number 123/42. Similar circular was issued by the state authority, my lord. This is the circular number 43 of 2019. Now, my lord, kindly come to serial number 1. What are the invoices, debit note on which restriction under Rule 36(4) of the WBGST rule shall apply? 36(4) is, my lord, the difference between the GSTR 2A, 2B, and 3B. If there is a difference, then the ITC should not be allowed. Now, my lord, the government has clarified. The restrictions of availment of ITC is imposed only in respect of those invoices, debit notes, details of which are required to be uploaded by the suppliers under subsection 1 of section 37 and which have not been uploaded. Therefore, taxpayers may avail full ITC in respect of IGST paid on imports, documents issued under RCM, credit received from ISD, which are outside the ambit of section 31, subsection 1 of section 37. So, my lord, on the basis of this mismatch, they do not have the authority to, my lord, disallow my claim of ITC, which I have paid at the time of the import only. They have to verify as to whether I have paid or not. And merely because on the portal, ICS portal, they are not finding. That's why I am disallowed without taking any reliance, placing any reliance on my document, my lord, which I produced. Now, my lord, kindly see one bill of entry I am showing you for your lordship better understanding. Kindly come to page 35, my lord.
35.
35. My lord, in the middle there is a table, my lord, regarding computation. My lord. Just from the bottom, my lord, there is a column for IGST, my lord. At the bottom, my lord, just kindly skip first 3 lines, my lord, from the bottom.
Yes.
And IGST payable as per my self-assessment, my lord, so declared in the bill of entry, 1,70,905. And thereafter, my lord, the customs duty is there, and total amount payable was, my lord, 4,27,731.
Yes.
And now your lordship will find this challan I have annexed, my lord. Page number 838, my lord.
And just for my understanding, since this is on the basis of self-assessment, if your self-assessment is wrong and customs duty is short paid, what will happen?
So in that case, customs will not release the goods until unless I clear the balance amount which has been disputed by the authorities.
Who will decide whether it is short or proper?
No,
Customs.
Customs.
What is that?
And they will, my lord, reject my they will make the provisional, my lord, assessment there.
This is done on this this bill itself.
Yes. No. Thereafter the notice has to be issued, my lord. Thereafter we will participate, and thereafter, my lord, they will decide as to what will be the correct rate
So
of the
on the basis of this, how will the authority come to the conclusion as to whether any proceeding in respect of the correctness of this amount is pending or not?
Well, they are not saying that this amount, whatever I have paid, man, I have claimed that only, man. So there is no dispute about this payment, what I am submitting. If suppose, my lord, higher duty is payable, then I will have to pay, and therefore I have to claim.
Payable and you have paid less than on the basis of this.
That for that, my lord, customs authority or the customs authority will say that you have to pay more.
So maybe that it is not being reflected because of any dispute being pending. Maybe we don't.
No, my lord, it is not the case, my lord. Whatever I have paid, it has been reflected, man. Kindly see, my lord, that I at page 88, I paid. This is the challan.
Page 88, I am at page 88 only.
Yes, 4,27,732, which includes customs duty and the amount of the IGST.
We have paid this, but the payment that you have made is absolutely correct, not challengeable, and therefore it should reflect. How do I know that?
No, man. This is not the provision. This is not the method that in case this amount of IGST or the customs duty, if it has been short paid, then it will not be reflected, my lord. If I have paid, my lord, it has to be reflected. At least, my lord, the amount which I paid has to be reflected, my lord. And I am claiming, my lord, the ITC on account of on the amount which I have paid. It is not that I am claiming the exercise.
My only problem is with 6.2. They have argued, their representative only has argued that custom has levied, but against some bills of entry, custom has not uploaded IGST amount on the GST portal. As a result, difference between GSTR 3B and GSTR 2B had been created with custom department.
Because their
only representative is alleging all these things. So
Yes.
until and unless custom department's presence is there, how
Well,
can this
they
be
could have verified about the genuineness and the correctness of my document from the customs authority, my lord, because they have that power, my lord.
Where that is what I wanted you to show. You took me to merits. I wanted you to show that.
The appellate
provision.
authorities, it's not within the appellate authorities jurisdiction, and whether this case has been made
That
out
was my question. Where is that
before the
provision?
adjudication.
In 70 is the summons, my lord.
They could have very well raised this issue in the reply, sir.
Okay, section 151. That is the well, their circular says that in case of any difference between the ITC,
No, you said there is a provision where they can call for records from them. Where is that provision? I wanted to see that.
kindly see section 151.
151.
The commissioner or an officer authorized by him may be by an order direct any person to furnish information relating to any matter dealt with in connection with this act within such time, in such form, and in such manner as may be specified there. Verification from my lord, one department to by another department. He will write a letter to the customs authority. My lord, customs authority will confirm as to whether these payments were made or not. My lord. That will
151, subject to correction, your lordship. 151 calls in other matters we have also used. It is in nature of a different power. If there is any
But they should
investigation,
always write to the department.
but that
asking
has
for elucidation.
should have been, they should have done.
Asking
So
for
they should
elucidation.
have done because I'm short of records. Then reply whether they have raised this case or not, whether they have made this case before the adjudicating authority. So I'm short of the instruction or anything like that, your lordship. Whether they have made the case before adjudication authority on a similar lines that
No, before the appellate authority, they have said this.
appellate authority they have said this, and
That it is
appellate
for the fault of customs.
customs they have said this.
So
But
they
appellate
they could have verified
but
this.
your lordship,
And in any case, this inconsistency is there. How will this
inconsistency is there.
inconsistency be resolved?
Inconsistency
Let him
is
apply his mind to it and let him confirm it with the customs authority.
Customs authority. Kindly direct so, your lordship, because as per my limited understanding, it's adjudication between authorities. He is not investigating. Like
That's
adjudication
there.
authority is
That's there.
it's in a different walks in a different line. And
Suppose if he had also written to the customs authority and custom authority does not provide any information, then in that case, what will
adjudication
happen?
authority, first of all, adjudication authority should have
What will happen there? If in a situation this person writes to the customs authority does not oblige by giving them the information, then again you will have to come back here only. Better you serve them and come. Serve Mr. Dev.
Well, kindly give the direction, my lord. Otherwise, Mr. They will not.
That will be better,
accept
your
that.
lordship.
See, where is their affidavit? Begin.
Well, it is that matter of transfer carried.
In this matter also, Bhaskar Prasad Banerjee is appearing.
Which matter he is doing that? This is the case for the entire day.
In fact, he will come at 2 p.m. So instructed
2
me.
p.m. all matters can't happen. I've already fixed 2 at 2
Kindly
p.m.
fix on 2 p.m. if possible.
Not today then.
Get floor.
All matters I can't have at 2 p.m. Next.
My lord, keep this matter at 2 p.m.
No. So every matter at 2 p.m. Why?
It lags in court number 1, my lord.
Who is at legs?
Srinjoy Das, Mr. Srinjoy Das.
Lordship, on the earlier occasion also.
Yes. Time was played for by somebody. What is the matter?
My lord, matter is that only
They're coming from the appellate authorities order, your lordship.
challenging the
happened?
appellate order.
What has happened?
Issue is that, my lord, only interest.
Huh?
Only interest. Page number 53.
Only interest means?
I have challenged the DRC 07 adjudication order. Then appellate authority modified the order. Tax is 0, penalty is 0, but interest is still lying.
Lordship, if subject to correction, IGST portion, there was some conflict regarding the IGST portion. So IGST portion waived off. After that, CGST and SGST stands. And interest portion regarding IGST subject to correction. Interest portion regarding IGST, it was still.
Very well, I'm making not today. Ask him to come tomorrow. Next.
Get.
Well, this matter is as regards to Malad. Have been issued.
Union, so we don't have a workshop please for the CGST.
Where is he?
I think he is in base.
Service.
The body Mighty
No, Uday, since morning I have not seen him. Malad. I'm over here since 10:15. Malad. Or if it even service.
What is the matter, Mr. Chorale?
Malad, ab initio cancellation of dealers, Malad. ITC from I have purchased, Malad, against my inward supply. I have availed ITC. Malad, from retrospective date, Malad, the registration of the selling dealer has been
Now
cancelled.
because Mr. Bhattacharya is not here. What should I do?
The annual office period, Malad.
Not today. What else?
Well, affidavit service, Malad.
Not
Today, Malad.
Should I record an order?
Simply sit and not today. Unless if he wants to file the affidavit and service, then my lord can.
Well, it is, if he, but since I know that as because I was on the other side, Malad. Malad.
Lordship, I am for the petitioner.
This is that matter,
Yes,
apportionment.
Yes, Your Lordship.
Yes.
Lordship, the slight deviation was that the SGST amount has been recovered in full, but the CGST amount has not been recovered yet. Lordship, that's the only deviation, and the appeal was dismissed only on the ground that pre-deposit was not made.
How to resolve this?
Lordships, on the previous occasion, Mr. Chakraborty had mentioned that 5% would be sufficient if that is to be paid. Lordships, I have gone through the provisions, Lordship. I have to pay 10% of the CGST amount. Lordships, may kindly direct that and we'll make the payment.
That is better.
Yes, Lordships, because 10% of CGST and SGST would actually mean 10% of the entire demand. So then 10% would be the best thing to do, Lordships. Lordships, a supplementary affidavit was also there.
As also, I will not be able to finish in 2 minutes, 3 minutes, my lord. I'll take at least 15, 20 minutes.
Then I know Mr. Bhattacharya is over there. For that reason, my lord, I am also.
My lord, in that event, my lord, kindly make it now because I have got a 2 p.m. fixed matter before the Honorable Chief Justice.
Not today, I have already.
Yes, not to the Kodis.
And my lord, earlier matter, I think your lordship passed it over. I think, my lord, my item number 14.
Yes, 2 p.m.
2 p.m. My lord, in that event, my lord, may I argue, my lord, and then you say here.
Argue just now, you cannot argue any time according to your will, you will come and argue. That cannot be permitted.
Then, my lord, that matter can also.
So you talk to your other side in front, in presence of the other side, I made it at 2 p.m. He was there.
Like you were there, I informed, my lord, that.
The time was short. Say, your junior was here. She said 2 p.m. He's there.
My lord, if you also takes up, my lord, tomorrow, my lord, then, my lord.
He wants it not today.
Not today, then when? Tomorrow. Tomorrow, then let it be day after.
This is item number?
Item number 14. 14.
14. 14 টা তাহলে পরশুদিন করে দিন।
Yes, sir. Yes, sir.
Now they have some problem. Then let it be tomorrow.
Not today or when? What do you want? Please tell me.
Well, this matter, my lord, my learned friend, to that extent, my lord, is correct. He's
Is correct. Saying now I'll not pass an order in 1 minute.
My lord,
Don't take it according to your convenience, Mr. Bhattacharya.
Tomorrow. My lord, tomorrow.
Then let it be tomorrow. Not today.
My lord, item 20 or so, if you want tomorrow.
20?
I appear in item 20.
Item 20, well, next item, item 20. On Wednesday, if you lordship takes it.
If it's on Wednesday, I'm comfortable. Wednesday, if it may permit.
20 তে একটা order record করে নিন। An adjournment is prayed for on behalf of the respondent, CGST authorities. Prayed for on behalf of the respondent, CGST authorities. Full stop. List this matter on বুধবারের ডেট দিয়ে 10 তারিখ।
Milan, if I may just say, I know I'm not going to waste much time, Milan. If no coercive steps can be taken until that date, because this is last year's order which I received. It's October 2024 order I received in the month of September 2025. So, Milan, I apprehend. I have shown on the last occasion I showed my.
One day nothing will happen. For one way asking accommodation only Tuesday.
Let it be, because then I'll have to enter it.
I understand. Fine.
Very well. Thank you. I have allowed the writ petition. I have allowed the writ petition. I have set aside the reopening notice. Dealt with your judgment. Yes. Yes. 11th April. And still it is within time. Within time. No, this was because the appellate order had been uh, appellate order was challenged, and there the court said that there is a provision for appeal. Here he has approached the appeal. But please listen to the court. This case which you are citing, this case is not applicable to the facts of the case, because in this case he does not want a decision. His appeal is pending before the appellate authority. During pendency of the appeal, if you execute the order, appeal becomes infructuous. No, it doesn't appear. This no, it is not on that point. See who had passed the order. See who you have copy. Please see who has passed the order. Order dated. Please see district magistrates. So in his case, who has passed the order? So he has approached that district magistrate. He has approached the district magistrate. You are confusing things. Against the order of the subdivisional officer, district magistrate is to be approached. He has approached the district magistrate. He has done the right thing. No, not that's why. Then district magistrate passed an order. Against the district magistrate order, the petitioner had come here. He is not here before against the district magistrate's order. He is here to get the appeal expedited, and in the meantime, the appellate authority will consider his application for interim stay. Yes. This writ petition
The petitioner hearing is challenging an adjudication order. On the grounds that it has been passed, he is basically challenging the imposition of penalty. On the ground of the facts of the case will be like as the valuer. He certified some goods. Now, some goods were intercepted lying at dumped at the highway. Samples of those goods were drawn, and based on such samples, there is no stay, but
Yes, 51 crores. Same for everybody.
same for everybody. My lord, for our goods, yes, yes. My lord, now comes to the provision of law, my lord, in imposition of penalty.
Yes.
My lord, kindly take section 112 of the
Section
Custom Act.
112.
The penalty has been imposed under section 112A3.
A3.
But section 112A deals with imposition of penalty upon any person who, in relation to any goods, does or omits to do any act, which act or omission would render such goods liable for confiscation under section 111 or abet the doing or omission of such act. Now, my lord, kindly take clause 3.
Clause 3.
In the case of goods in respect of which the value stated in the entry made under this act, or in the case of baggage in the declaration made under section 77, either in either case hereinafter referred in this section referred to as declared value is higher than the value thereof, to a penalty not exceeding the difference between the declared value and the value thereof, or 5,000 rupees, whichever is earlier. And my lord, section 114 AA. I will kindly take section 114 AA. AA. If a person knowingly or intentionally makes or signs or uses or causes to be made, signed or used any declaration, statement or document which is false or incorrect in any material particular in the transaction of any business for the purpose of this act, shall be liable to a penalty not exceeding 5 times the value of the goods. My lord, the valuation itself is a question for imposition of the penalties. My lord, may I take back to your lordship in the order? My lord, kindly take page 52 where the order starts, my lord.
Page 52.
At para 1.2.
Yes.
During investigation, 45 live consignments were found at Kolkata Airport Air Cargo Complex, which were not cleared, taken delivery by the concerned importers. Examinations of the live consignments were done in the presence of GRI officers, customs officer, representative of customs broker, Sri Sunil Kumar Verma, government approved valuer, and 2 independent witnesses under Panchnama proceeding. After examination of the said consignment,
What are you trying to
yes, my lord, what I am trying to make out is, my lord, samples those were relied upon by me for the purpose of ascertaining the value of the goods which have been disregarded. Those samples have not been taken into consideration for arriving at the value by the authority in determining the value in this case.
Where is that clear from here?
Yes, my lord, kindly takes this whole paragraph and the next paragraph. The samples were drawn for the purpose of valuation and the purpose of testing the actual nature of the goods imported. During investigation, DRI also recovered goods pertaining to 7 earlier bills of entry, which were after clearance by the customs were found to have been dumped on the roadside at Kamsara and Jagannathpur. The concerned person who had been hired by the members of the syndicate confessed that his job was to dump those stones after taking delivery of the same from the customs broker. He also admitted that he had dumped earlier consignments also in similar manner. Next parameter 1.3. The samples were drawn from the live and dumped consignments. Well, these are not the consignments which I filed the valuation report. Well, my valuation report pertains to. Kindly take page 65. 65. Table C chart is provided, my lord. Yes. Serial number 3, 4, 5, and 6. These are the 4 bills of entries that I have filed my valuation report. And what they are, my lord, dealing with, my lord will kindly see. Again, come back to page 53. Please. And kindly consider para 1.6. The samples were drawn from the live and dumped consignments. Now, my lord, damped consignments, your lordship will find that
Yes, this doesn't appear to be a jurisdictional error.
my lord, in every case, my lord, what has happened, in every case, this valuer and many other valuers have been implicated. Now, against all those cases, my lord, the repetitions are pending. My lord. Of the orders I am carrying. My lord, this is a list from the official website. My lord.
My lord, whether that has come to my lord, 2022.
Yes,
Yes.
yes, since then it's going on, my lord. There is no change.
One of 21, one of 22.
And the,
Order in my lord,
not different, my lord. Only exporter is different, issue is same. Issue is no, I am not going on merits, my lord. I am not going on merits. Might be, my lord.
I can admit it in white affidavit, keeping the point of maintainability as well as
No scope for meeting, my lord. Very well, my lord.
Liken it. The writ petitioner assails an No, items have been called on. Madam, list is calling. List is being called on. Mention it in the morning or at the time of rising. Make this lordship, I am for the petitioner. Last time, who is for the other side?
Mr. Chakraborty was there the last time. Last occasion, your lordship, the question, your lordship, that DRC 01, there is no digital signature, your lordship. This is now what I have seen that this is Supreme Court is in session of these matters.
No, Chakraborty. In this matter, Mr. Agarwal had appeared. No, he's there. The matter where this. He was sitting there. No, I was handed up an order. There is a typo. Needs to be corrected. Yes. Just a minute. In the order that you handed up to me, there is a typo. See page 9, paragraph 9.
That na, me need to देखते ना बाबा ये.
This sentence is incomplete. Lose one forum is missing. Lose one forum is missing. So I'm bringing it as to be mentioned and both of you be present. Because it doesn't make sense that way. There is a bereavement. It will appear as to be mentioned. I'll
In this matter,
yes.
the DSU 01, DSU 07 has not been signed, digitally signed, your lordship. This matter, I think Mr. Chakraborty has shown me a judgment that is an order that this is Supreme Court is in session of this matter, whether it will be digitally signed or not. Now that they have, no, Telangana High Court, your lordship, was of the opinion that without the digital signature, you cannot, the order is known as in the eye of law. Now there is a judgment of our court, there is an order of our court, single bench order, that if it is uploaded and then it is very much formality has been maintained. But this judgment, your lordship, I am just distinguishing on this fact that this is far inferior. This, because that does not consider the rules. Rule 142, Telangana High Court exclusively considers the 142 rules. Then comes to an opinion, conclusion, that this has to be done. 142 of? 142 of the West Bengal GST rules, your lordship, 142 sub rule 1. And I'm just this is the judgment of Telangana High Court, your lordship, that 37 and 38 paragraph. Guru, it is different on 37 and 38. How much? 37 and 58. He has considered the rule. The 142(1) gives you have to, this is the form is mandatory and the content of the form has to be followed in that in the way it has been stated in the form. That is the ratio of these two. Now this single bench judgment, your lordship, this Mr. Chakraborty is relying upon, does not consider any rule. It just says that there is, once it is uploaded, it is automatically authenticated.
Where is that single bench judgment?
That judgment, your lordship, that will handed over to you, lordship. That in day. Justice Kapoor's judgment.
Not today. Not today.
Yeah, I've handed over a judgment of Telangana High Court, your lordship.
तेलंगाना का अरे
23 I am appearing, my lord.
25.
Lord, based on a intelligence report conducted by the DGGI, my lord. Yes, we have served, my lord. CGST, my lord. CGST. Effective party is, my lord, deputy director and the assistant commissioner. We have
been served.
yes, on 20th.
Yes.
So, Lord, the so-called notice was issued based on the intelligence report drawn by the DGGI, my lord. Lord, the deputy director, DGGI has issued the so-called notice, but the order was passed by the assistant commissioner, my lord, respondent number 1. The effective party is, my lord, the respondent number 1.
Very good.
He has passed the order.
This is the order.
No, my lord, my lord, kindly see, on 18th, they have, after, my lord, this so-called notice was issued by the deputy director Patna, we appeared and complied with the so-called notices, my lord, by giving the reply. Thereafter, another DRC 1 was issued, my lord, that is a summary of so-called notice, asking me to reply on 18th. And, my lord, they have passed the order on 18th, my lord. And the so-called notice was also issued on 18th, my lord. Kindly see, my lord, page 66. Yes. Well, your lordship will find at the top, 18th June 2025.
Yes.
This so-called notice was issued. Now, I will kindly turn page 67. Here, your lordship will find the date by which reply has to be submitted on 18th. Now, kindly see the order, my lord, at page 68. On 18th, they passed out. Page 68, and my lord, the signature your lordship will find at page 75. First violation of the, my lord, the principles of natural law. And now, another point is there, my lord.
Everything done on the same day. How to let them come back.
Well, the deputy director has issued a so-called notice
May it please your lordship, I am for the petitioner. In this matter, your lordship has directed me to serve at the Union of India as a party. In deference to your direction, I have added and served upon the Union of India also. This is the affidavit of service, your lordship. This. Now my point is, lordship, this pertains to 2019-20, and the last date of filing the GSTR 1, GSTR 9 is 2021. So the order should have been passed within 3 years, that is 31st March 2021. But they passed it on 14 June 2024 by dint of a notification, your lordship, that I have challenged the notification. The extended period which cannot be because there is no force majeure. Because under section 163A, 68A, there is a force majeure is required only for passing in extending the period of time. Now this application, there is no force majeure at that point of time, your lordship. There. Page 56, there is a notification being given, your lordship.
You have come up against the appellate order.
I have come up against the order of the original order in original.
Order in original is taken.
Lordship, it is dated. Well, appellate order, your lordship. 2nd of June 2025, your lordship. The order is dated.
Affidavit have to be invited.
This is against the appellate order, your lordship. Sorry. (41 to 54) is the appellate order, 2nd of June 2025, your lordship.
Very well.
This point taking 0.10%, 10% takes case.
Because that is the usual order. The petitioners assailed
Here, your lordship, that 22 other case, your lordship, that GST 01, 07, nothing has been given, your lordship, no signature. No, no, digitally signature. Digital signature. Digital signature has not been given, your lordship.
So digital signature is not there.
Not there, your lordship. Digital signature is not there.
We bring that order and bring Justice Kapoor's order also. I'll see. If I have not to take it.
Not today. Mate, is your lordship, I am for the petitioner. Your lordship, the only point is here the GST 01 has not been issued. But they say that they have been issued. Lordship, they are saying. So, yes, very much so.
The petitioner assails appellate order or adjudication order?
Adjudication order, your lordship.
Assails and adjudication order dated. Adjudication order dated. What is the date of the order? Anyway, लिखो. The petitioner assails and order dated
no discretionary power given by the statute
No,
to
no,
access
your
it.
explanation where is that?
That has not been annexed.
Mr. Ghosh invites the attention of this court to the appellate order, impugned in the writ petition, and submit that it was the petitioner's case before the appellate authority that the accountant of the accountant of the petitioner had fallen sick and was undergoing treatment at the relevant point of time when the appeal was supposed to be filed, and as such, the appeal could not be filed within the prescribed period. Full stop. Inviting the attention of this court to page 2 of the appellate order, within bracket, page 2 to paragraph 2 of the appellate order at page 2 thereof. Paragraph 2 of the appellate order at page 2 thereof, comma, sometime. Ethanolicity, at the outset, Mr. Ghosh submits that he is not pressing. He is not pressing the challenge prone to the notification, not pressing prayer A mentioned in the writ petition, which reads as follows: data copy for this tax period. I mean, this tax period I will have. For this tax period, I will have. Whatever is there here, this tax period. On the same matter, I will on 60 on the next tax period I will take. But in this matter, you are not that in this matter, correct? That in this matter is not good. On 1920, I am still I have a still belief that on 1920, I will win in the Supreme Court. Not in 1819, but in 1920. You can't get it. Inform him that I am incorporating that. No, original text. I will call Magadai. Okay. Okay. What? I will do that. Original side. Definitely. Next paragraph is different point. Points are different.
May I have my lord leave to mention the matter for the extension of interim orders expiring this month end. 3 matters are there, my lords.
I'll record that. Ask him to be here at 10:30 tomorrow so that I'll not sign it once I have. Passing it to.
Lord, petitioner made import of PVC flags of Malaysian origin, my lord. And my lord, he paid the duty, but my lord, if the goods, my lord, imported by the petitioner is of Malaysian origin, then my lord, the anti-dumping duty is not payable or exempted from the anti-dumping duty. After the import, my lord, the DRI conducted inquiry and my lord, the investigation. In this process, my lord, petitioner paid 44 lakh and on, my lord. Thereafter, so-called notice was issued, and my lord, since the department relied upon various statement of the various persons, my lord, we approached this honorable court that since the department is not allowing cross-examination, so no order should be passed based upon this so-called notice. The honorable court allowed, my lord, our application, and my lord, the cross-examination was allowed. Thereafter, my lord, the department passed an order confirming the amount of duty which has been proposed in the so-called notice, and the amount which we have paid, they have appropriated. Thereafter, we filed an appeal before the state state. State state allowed our appeal, my lord, and my lord, and with consequential benefit. Now, the amount which we have paid, we are entitled to refund, my lord. So we wrote a letter to them for refund of that amount, my lord, but they are not refunding. So we have come against the inaction on the part. Now, my lord, this order passed by the honorable state, my lord, is appealable before the honorable High Court, my lord. They have filed one appeal, my lord. But my lord, we have filed in the month of July, and thereafter on 3 occasions this matter appeared before the Lord. So no escape has been taken already. On whatever it The amount of duty involved in this case is less than 1 crore, particularly in which case, in the case of the petition. The department, the CBIC has issued a circular that in case of the threshold limit involving the duty of rupees less than 1 crore, the department should not prepare appeal. This is the circular. So they can. No, no. Three conditions have been carved out in this circular. One is where the constitutional validity of the provisions of the Act or rule is under challenge, that is not under challenge. Where notifications, instruction, order or circular has been held illegal or ultra-vires, that is not under the challenge. Classification and refund issues which are not are of legal and or recurring nature. This is also not the case. Only in these three cases,
But for how long? Because this order of testat was passed when? In February. So next February is approaching.
13th February it was passed.
If the appeal is within time, let us wait for it.
Yes.
The petitioner
Madam, led by Mr. Satya Nujumwala is appearing in court number 1.
Your Lordship, this is that unreasoned order, Your Lordship.
Similar matter.
Your Lordship?
It's the cognate matter of the part which was being heard.
No, Your Lordship, this is that matter which was being heard.
It will be same matter.
Yes, Your Lordship.
Where is Mr. Up to you, up to you.
Page number 2 to 4, my lord. It will be made because some different pages are there, my lord.
2 to 4.
2 to 4. If you lordship kindly see Roman 3, from that finding also, I have carefully gone through the records of the case as well as the written submission dated 6/5/2025 and 6/6. My lord got it, man. 2 to 4.
2 to 1, Your Lordship.
2 to 1.
It is 4 होगा ना? Now, my lord, Roman 3, my lord, of the 2 to 1 probably, my lord. Sri Vikas Bose was actively pursuing the clearance of the import container independently in absence of the direction from the importer. Now, next page, my lord. Sri Vikas Bose had already proceeds towards getting the container released from the shipping agent using documents having false information and also paid the necessary charges from his own pocket. He further failed to disclose and refused to divulge details about the supported supplier or any of the parties involved in the impute consignment for the purpose of selling his accomplice in the illegal activity of smuggling.
But these are all findings.
These are these findings, but for finding is based on
Basis for this.
what is the basis? Not before that, my lord, we have taken the statement of the importer who at the time of giving the deposition before the learned court below when he was arrested, because this is a case of smuggling poppy seeds under the guise of, my lord, detergent powder. Now, when he has given the statement that he knew what was the materials inside that container. Now,
Where is that?
my lord, 1 minute, my lord. You will not kindly come to page number 199. Probably it's 197, probably, my lord's brief.
199 is 196 in my.
196, 3 pages are depicted. Now, if your lordship kindly come to paragraph 4, arrest of Sri Lafa, so the importer's name, my
Arrest
lord.
of Sri Lafa,
Ah,
yes.
yes. If your lordship kindly come to Roman 1, he had admitted to have been known about the container contained goods other than what was declared in the documents. Now, when the department has intercepted, my lord, that on the basis of that intelligence, that product got something which is misdeclared. Now, at that moment, my lord, he has admitted that he knew what was inside the container containing the poppy seeds, which are restricted items. Now, if your lordship kindly see the statement of the Vikas was, he himself stated that I knew the importer for 10 to 12 years and I also have done the business in the past also. And he from his own pocket, he has paid the payment, he made the payment for goods to be cleared, my lord. But these are the things
which culminate into the proceeding and which prompted the adjudicating authority come to the conclusion that he is actively involved, then what his personal interest, what his personal, my lord, to get the goods to be released, my lord. If your lordship kindly see, I was referring last occasion, if your lordship kindly see, paragraph number, page number 195.
Yes.
Statement of Sri Vikas Bo 3.2, paragraph Roman 4, my lord. He mentioned that, my lord, got it, my lord. He mentioned that he received the original bill of loading and authorization letter from the importer. Upon learning about the alert notice against the import consignment, he called the importer Sri Lapcha such and such to be present during examination of the impugned goods. Upon coming to Kolkata, just prior to the date of examination, he was supposedly already informed by Sri Lapcha that the imported container contains proceeds. That before the date of examination, it was within his knowledge that the goods containing the poppy seeds. Then as a
But there is no certainty. It says he was supposedly already informed. There is a supposition. There is no ascertainment. On the basis of supposition, how can he impose?
Why he has called that person of that Lapcha importer? Why he has called? Because he knew that the goods might have got something, because there is an alert notice from the intelligence of the department. Therefore, he called him and he informed him that as a customs broker is acting as an agent of the departmental officer, and it is his obligation, as and when he came to know that something is there, some deviation of the proceedings, some misdeclaration goods are there, he should have immediately informed the department that look, this goods are such and such thing, and it is duty of the customs broker even under the CBLR, my lord, to advise his client to act in accordance with the provisions. Now, when this is a restricted items, now when he bring to the notice that this is a poppy seeds, not as a detergent powder, he should have immediately informed the department that look, this is the goods poppy seeds. You just I am informing you, but where is that information? And what is the personal interest, my lord? He has himself paid this 33,000 to get the goods to be cleared. But these are the thing, my lord, that prompted, my lord, this comes to the conclusion adjudicating authority that yes, he has the knowledge, whether he has the knowledge or not, prior knowledge or not. These proceedings, these adjudication, this deposition, if your lordship kindly consider its entirety, it will come to a conclusion, definite conclusion that it was within his knowledge. Now, just to get the whole this, no, I don't know. Last occasion I have submitted one judgment of the Honorable Chief Justice Sai Datta clearing. He has said, if your lordship kindly see,
yes,
2022-19 syntax 222. Now, what he is case, I am a customs broker. Whatever documents I have got it, I have submitted in, my role is enough. But if your lordship kindly come to this judgment, question number 2. If your lordship kindly, question number, this is appeal against the tribunal's order, my lord. What has been from the question number 2, if your lordship, I'm just read out, my lord, whether the learned tribunal should have considered and add in law in considering that the petitioner, after obtaining the authorization from the importer, that is Surya Trading Delhi, in course of ordinary business, filed the bill of entry on the basis of the invoice, packing list, bill of lading, import, export code, number, etc. provided by the importer. The goods were examined by the customs officer and clearance was done and handed over to the importer. As a CHA, the petitioner was never a party, or it is not possible for the petitioner to be a party under the undervaluation of the goods, as your petitioner is not in no way related to the goods. There is no evidence being adduced, as there cannot be any to the effect that the petitioner is in any way involved in such activities for the question of aiding and or abetting in the duty evasion in support of the bills of entry filed by the petitioner, as a CHA cannot arise upon. Now, if your lordship kindly see this paragraph number 6, as could be seen from the order of adjudication, the allegations against the appellant are very specific and had been noted in paragraph of the order in original, which is the basis on which show cause notice was issued. If your lordship, now in our show cause notice, we have stated what is the specific allegation against the petitioner. We have given the opportunity to file his reply. Now, adjudicating authority, after considering the role played by the petitioner in the alleged in the smuggling activities and the statement of the importer, and that initially he has submitted that that I don't have other documents, only the bill of lading and something. But subsequently, when that shipping agency, they have stated that the petitioner himself, he has issued an email, and where we have submitted all the documents. Now he is giving, while giving the statement before the customs authority, he has not disclosed all these things. We came to know the moment we taken the statement from that shipping agency that he is making contradictory statements. So if a person come with a clean hand that yes, I don't know, this is the document, then why playing this hide and seek, my lord, hide and seek games, my lord? What is his interest? Because, my lord, to evade the payment of customs duty. Now they are coming from this, because Bhutan is an all landlocked country. This is a transshipment. They will unlift the goods and they will send the actual goods to that Bhutan, my lord. Just to evade the payment of customs duty. Now the question of whether it is a reason order or not, any reason has been, for my submission in this regard would be that the reason has been given. Maybe this is not a good reason for the petitioner, but he has given some reason, so it cannot be considered. It is not the case that this order has been passed without authority of law. There is a violation of any principle of natural justice. It is up to the appellate authority to decide to take into consideration any other factual aspect involved or not. So for my humble submission before your lordship, this is an appealable order. Let the petitioner to prefer an appeal before the appellate authority.
Yes, madam.
Your Lordship, again, Your Lordship, I'll first answer my learned friend. Although, Your Lordship, my main submission is that this is an unreasoned order. Even the finding is a copy-paste. But, Your Lordship, I will answer all the allegation. Your Lordship kindly takes the finding which my learned friend placed. According to him, this is the reason. Your Lordship, at page 221, Your Lordship,
21.
Your Lordship, I had placed on the last occasion that this point number 1 to 6 is also a copy paste from the show cause notice. I had taken out 2 pages and Your Lordship, I had handed over to show that this is also a copy paste. However, Your Lordship, I'll answer this. Your Lordship, because Bose was actively pursuing the clearance of the import container independently. Your Lordship, I am the
Where are you
author.
reading page?
Page 221 of Your Lordship's brief.
Yes.
Bottom, Your Lordship, point number 3. Your Lordship, the allegation is that I was independently in the absence of direction from the importer. Your Lordship, I am the authorized CHA. So I have to do, this is an admitted fact. So authorized CHA will do what is the role of a CHA, Your Lordship. So Your Lordship, he handed over documents. Bikash Bose had already proceeded towards getting the container released from the shipping agent using documents. Next page, Your Lordship. Having false information and also paid the necessary charges from his own pocket. So, Your Lordship, 2 things they are saying. Document having false information. Your Lordship, on the last occasion, I had placed the first finding at page 220, Your Lordship, that I find that the documents related to the impugned goods, page 220, point number 2.2, Your Lordship. I find that the documents related with the impugned goods, the goods have been declared as detergent washing powder. So, Your Lordship, this was declared as washing powder shipped from Malaysia. This only I had produced. So, I cannot be blamed for misdeclaration. And second part, Your Lordship, I paid the charges. This I have answered in reply to my to the show cause, Your Lordship, at page 173. Page 173, Your Lordship.
Yes.
Your Lordship, point number 7. Your Lordship, last 3 lines. It is a fact that the custom broker paid the charges to the steamer agent for obtaining DO as per prevailing practice in the business parlance, subject to realization from the importer. So, Your Lordship, on this, I want to hand over a circular which says that it is a trade parlance. Your Lordship, although this is, because this is an unreasoned order, paragraph 2.2, Your Lordship, that this is a trade parlance, custom broker pays in advance, then recovers it later. Now, Your Lordship, second point. So, Your Lordship, these 2 points, paragraph 2, Your Lordship. Your Lordship, last 2 lines. Later recover these charges from the customer along with their own charges. So, this trade parlance is known, Your Lordship. No adverse inference could have been drawn on the basis of this payment. And Your Lordship, this has been I have dealt with this in my reply, which Your Lordship, I don't find it being considered in the finding. Now, Your Lordship, he failed to disclose and refused to divulge detail about the supposed supplier. So, Your Lordship, supplier's detail is there in all the documents which are with the customs, Your Lordship. All invoice and everything has the supplier's detail. There is no scope for suppressing it because goods are coming from Malaysia. Supplier is sending it, Your Lordship. His details are evident in all documents, Your Lordship. And Your Lordship, the point number 2, Bikash, Your Lordship, previous page 221. Bikash Bose tried to mislead the investigation by stating that he did not have any documents in relation to the consignment other than the original bill of lading and authorization. To this allegation also, Your Lordship, I've dealt in my reply, which is not considered at page 175, Your Lordship. Point number 14. Here it is pertinent to mention that the noticee has submitted all original document to DRI at the time of examination of goods, para 2.2 of the show cause notice, and also the adjudicating order, Your Lordship. Kindly takes page 195, Your Lordship, 192, Your Lordship. It is the department's own admission, para 2.2 again, Your Lordship, at page 192.
Para
2, Your Lordship. Before the examination procedure started, the CHA provided copies of documents related to import consignment, including bill of lading, invoice, packing list, import license, letter of authorization for the CHA, etc. So, Your Lordship, I had handed over all documents which was in my possession. Now, Your Lordship, my learned friend had placed one paragraph where my statement is recorded. Your Lordship, that statement itself shows my bona fide, Your Lordship. Your Lordship, that statement is at page 195. Point number 4.
Yes.
This is my statement, Your Lordship. Point number 4 was, Your Lordship, if they are relying on my statement, they have to rely on it completely. He mentioned that he received the original bill of lading and authorization letter from the importer upon learning about the alert against the import consignment. He called the importer to be present during the examination of the imported goods. That is the procedure, Your Lordship. If the goods are being examined, the importer, the shipping agent, and the custom broker all are required to be present, and they were present, Your Lordship, in this case. Upon coming to Kolkata, just prior to the day of examination, he was supposedly already informed by the importer that the container contains poppy seed. Now, Your Lordship, I've just prepared a short list of dates which will show that my work of paying to the the delivery order was over before the alert was issued. There was nothing I could have done one day prior to examination, Your Lordship. May I hand over, Your Lordship? And Your Lordship, I'm also giving a copy to my learned friend. Your Lordship, along with the event, Your Lordship, I've also mentioned the page number for convenience. Your Lordship, serial number 1, goods exported in sealed container from Malaysia for transshipment. Your Lordship will find at page 192. Your Lordship, there's a table.
Yes.
Second column, bill of lading. Date is 4/6/2024. In the table, Your Lordship, has Your Lordship.
Yes.
So, Your Lordship, this is the first date. Goods were exported from Malaysia. Then, Your Lordship, documents emailed to the shipping agent. On 10 June 2024, it is a part of the order again. Page 197, paragraph 5. Point number 2, Your Lordship. Next page, Your Lordship. We'll find, Your Lordship, point number 3, third last line. On 13 June 2024, delivery order was handed over to Shri Bikash Bose. Has Your Lordship found that, Your Lordship? Page 198, Your Lordship. Point number 3. Last 3 lines, Your Lordship. The date is given 13 June 2024. Has your lordship found that, your lordship? And your lordship, now again at 192, your lordship will find that alert was issued on the top, your lordship, fourth line. Alert dated 14 June 2024. Last three words, your lordship.
192.
192, your lordship. On the top, acting on the intelligence following Bhutan brown transshipment container imported by so-and-so was put on hold by alert dated 14/6/2024. The document is at page 71. So, your lordship, alert was issued after my work was done. Now, your lordship, next point is before the examination procedure started, petitioner duly submitted all document to the authorities. And your lordship, one day examination, your lordship, took place on 24th June 2024. And your lordship, the statement which is relied is one day before examination, the importer came to Kolkata and informed the petitioner. And your lordship, next paragraph, 24/6/2024, after the examination of goods, the importer was examined. He also admitted that goods are misdeclared. And your lordship, he for the first time produced a new invoice which had 2 items. And your lordship, from the invoice which I gave to the customs and shipping line, there was only 1 item. This will be evident from page 198.4, your lordship. Page 198. Point number 4. Your lordship, the shipping line's representative was being examined. He said that he was not provided, his company was not provided with this invoice which had 2 items. So I had given this invoice with 1 item which I had to the shipping line, and similarly, your lordship, customs also, your lordship, I gave invoice which had 1 item, page 194.5, because this is what I had. Page 194, point number 5, your lordship, where the custom is confronting the importer with the invoice I gave, which had only detergent powder mentioned. So, your lordship, from facts, I have shown that, your lordship, my bona fide, and I've also shown that I've taken defense in my reply, which is not considered, which is not found in the finding, your lordship. And your lordship, the finding and including the rest of the order is a copy-paste exercise I had shown. Your lordship, quickly, I will just summarize my argument, your lordship. Your lordship, on the last occasion, I had placed a judgment, 2010-9 SCC, saying that, showing that the order must be reasoned, your lordship.
Yes.
And along with that, your lordship, I had also cited one unreported judgment. Today, I'm carrying a copy of the reported version from SCC, your lordship. Paragraph 3 of this judgment. Your lordship, I had cited this earlier, but I did not have the reported version.
Is Saroj Maurya?
Your lordship, yes, your lordship. Your lordship, the next point, just summarizing, your lordship, the next point was that your lordship, I've prepared a short note. May I hand over, your lordship? And your lordship, I will also deal with the judgment which my learned friend cited. Your lordship, that judgment itself says that the modus was clearly first, your lordship, may I just deal with that judgment, your lordship? In that judgment, your lordship, at paragraph 6, it is clearly stated that the modus of the appellant was clearly established, and there was a factual finding, which is absolutely missing, your lordship, in this case. So this judgment, your lordship, has no application to my facts, because here, your lordship, it is a totally unreasoned order. So, your lordship, first is that it is an unreasoned order. Next, your lordship, I have just set out the paragraphs from where what has been copied and pasted. There is no discussion or reasoning in the impugned order about my reply and the submission I made, your lordship. And your lordship, the penalty which is imposed under 112A, B and 114A, that is also beyond it does not, the ingredients of the offense is not established. That's why it's vague. On that, your lordship, I had cited one unreported judgment of single bench, your lordship, in Shubham Chatterjee versus Union of India, your lordship, to show that mens rea, knowledge, intention, and connivance has to be proved, which is not here. And your lordship, I never had the access of goods. This is an admitted fact. It came in a sealed container. It was a transshipment to Bhutan, your lordship. So 112B could not have been applied. And your lordship, penalty under 114A is not applicable for importers. On that, I had cited one Sistat judgment, your lordship. And your lordship, the finding is also perverse, which I have just now demonstrated, that I said that I had handed over documents. The payment to the shipping line is a normal trade parlance, your lordship. On that, I have given a circular also. And your lordship, the name of the supplier is in all the documents which is coming from Malaysia. There was no scope of hiding that. And your lordship, there was a circular which I had cited on the last occasion, that custom broker as an abettor should not be added in a routine manner. And your lordship, one more thing here, they are saying omission commission as well as abatement. Both cannot stand together. Either or, it is an either or situation. But they have used both. Whatever they could have said, they have said, your lordship. Your lordship, that is all, your lordship. And your lordship, the Bhutan treaty I had referred to show that it comes in a sealed container, and release can be only from the when a guarantee is received from the government of Bhutan. At page 206, 207, your lordship. It is set out in the order, your lordship. Your lordship, to show that my delivery order would not have helped him release the goods. Only when a guarantee is issued by the government of Bhutan, he could have taken clearance of the goods, and that the goods were in the custom control under a one-time lock, which only the customs can open. That, your lordship, page 206, 207. That is all, your lordship. Your lordship, that 2024 SCC judgment, which I had just handed over, it clearly says that if there is no reason, your lordship, yes, the law itself ceases, your lordship. Paragraph 4 of this judgment. Grateful, your lordship.
If your lordship, just 1 minute, my lord. If your lordship kindly see 24 SCC judgment, my lord, Suraj Maurya. If your lordship kindly come to paragraph number 2. Here, my lord, the Supreme Court, why the Supreme Court has turned down the decision? Because the division bench has held that the division bench is in agreement with the approach and view of the learned single judge. Therefore, my lord, they, without giving any reason, they have stated that yes, we are in agreement with the view taken by the learned single judge. Therefore, this, my lord, observation given in the particular context of this matter, my lord, which is nothing to do in our case. And now, with regarding to this clarification that customer agent has to bear that expenses, that circular, this is in the context of to determine the service tax liability of the customs of agent. We do determine the service tax liability. In the context, it has been decided, my lord. This circular, what is the purport of this circular? What should be the service tax liability of a customs agent, because it determines service tax determined on the point of taxation, my lord. There is a on what point the service tax will come into play, and in that context, my lord, this has been decided by the circular has been issued.
Your lordship, here also he's copied from the show cause notice. So he has just said that I agree. In effect, he's actually copied the finding also from the show cause notice.
Very well. I'll keep it on one more day, then I'll pass the notes. We can.
Your lordship, for orders, your lordship.
Let me go through the file. I may
Sure.
have some clarifications. Heard which one? Item 5.
Item number 5, my lord.
Your lordship, I'll come back if my lordship has.
You want not today or no? What?
On 10th, my lord. Can you fix it on 10th?
Your lordship.
10th. 10 तारीख को.
10 तारीख.
Item number 6.
That's why I'm appealing for the petitioner, paying for not to lodgement late by which Anupa Banerjee is not well, lodgement paying for not today.
Not today. Yes. Mr. Banerjee is there. Yes. Pass over to Paul.
We have got the judgment, what is from his lordship.
Lordship pointed out his
Item number one. I had not gone through it. The judgment question.
Okay, copy আছে একই জিনিস আর এসিসি অনলাইন ভেরি গুড
Version. I have marked not in this version.
সেম থিং
My light friend may complete, then I'll submit, because I've gone through this, not possibly there are some points of distinction so far as this practice comes.
But the paragraph 13 of the judgment is the key point. That the Supreme Court.
What is the fact of your case? Let us know as we would have.
My lord, there is a suit for partition and administration amongst the family members. Now, my lord, the plaintiff wants to divide it in four parts rather. The plaintiffs possess 25% of it, and rest
25%.
Plaintiff possess 25% of the share, 25% share of the entire premises. My lord, the others 75% of the defendants. My lord, when the partitioner commissioner filed the report and draw the plan for partitions, my lord, then the particular drawing envisaged that the partition could not be possible and it cannot be butted bounded. Accordingly, my lord, the coordinate bench, my lord, ordered for the structural engineer, because the premises concerns a very old dilapidated conditions. The structural engineer, after having the consideration of the plans and etc., then the condition of the building, opined that the suggested drawing plan cannot be effective. The partition drawing cannot be effected in that particular premises. Accordingly, the partition could not be effected. And plaintiff then come forward with an application by saying that the property may sell out. My lord, in that juncture, my lord, the defendant, the petitioner before your lordships, applied for that, yes, we are ready and willing to purchase the plaintiff shares at the market price. My lord, that order was passed and we purchased the plaintiff shares, 25% shares. My lord, the sale deed was done and the entire price has been paid, stamp duty has been paid, etc. Now the final degree has been passed. Since the plaintiff sell out his shares, their shares in favor of the defendant number 3, my lord, the entire premises belongs to defendants. The defendant number 3 is the brother of defendant number 2. The another six. My lord, the defendant number 2, defendant number 3, and the defendant number 4, who is the son of defendant number 2, they are the co-owners along with the plaintiff. My lord, there was no rights created by the judgment of the preliminary degree. Preliminary degree has been passed on admission, and no third party right has been created. Since the property could not be partitioned with, my lord, the order has been passed by saying that yes, you sell out the property in favor of the defendant number 3, and defendant number 3 purchased the shares of the plaintiff. Now the final degree has been passed by recording the rights of the existing rights of the co-owners, my lord, and pass the final degree. And it is a very categorical statement, and the passes in the final degree. If your lordship kindly consider the order passed by the coordinate bench in the final degree drawn up.
Page?
Yes, my lord. I mean, final degree passed, and it's at page 87, if I'm not wrong. Page 87.
Page 87.
Yes.
Yes.
Page 87 is this is the final degree passed in the CS 91 2013. And if your lordship kindly takes up, there's a brief history has been uh, 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 recorded, and thereafter paragraph 5. At page 88. And before that, my lord, that record is things has been recorded by an order. I'm reading paragraph 4. From paragraph 4, I'm reading. By an order dated 6 June 2018, the court has appointed a surveyor commissioner to assess the impact of the construction on the existing structure, and if at all such construction is feasible according to the plan prepared by the commissioner of partition. Then paragraph 5. The structural engineer has filed his report, wherein it is mentioned that no major addition or alteration in the said building at present could be carried out, since the premises cannot bear the impact of fresh construction to effect the partitions as per plan prepared in consultation with the partitions premises amongst the plaintiffs and the defendants in proportions to their shares at all are not possible. The defendants in proportionate to their shares are not possible. But the partition were not possible according to structural engineer, and that was the finding of the court also, and things has been given and order has been recorded to that effect. But since the partition was not done, it was not done in butted and bounded, then according to provision of the Act, the Stamp Duty Act, section 2, subsection 15, this cannot be treated as an instrument of partition. That's my objection before the assessment authority. Assessment authority first, my lord, when the final degree has been drawn up by the department, it was sent to the assessment authority, to the collector for the assessment. But then they come up with an assessment order by saying that you have to pay 2,61,000. Why? It was two legs. One is 2,16,000 on for the purpose of sale, which we have already paid, and another is for the purpose of partitions, that is Article 45. These are the two portions of this assessment order. Whenever the moment we file the writ applications, my lord, we serve the writ applications, then they come up with a fresh assessment order by saying that no, you do not to pay the 2,16,000, you just pay 45,000. It is for the purpose of partition. Now, my lord, my question, my objection, I raised objections by filing and written objections before the collector at the time of hearing by saying that this final order cannot be treated as an instrument of partition. Cannot be treated as an instrument of partition. But because it was not the partition that was suggested by the Commissioner of Partitions, my lord, that was not been effected. Number one, and no fresh right has been created. That's the thing, my lord. And now the fresh assessment order has been passed, my lord. That's why, subject to leave of the court, my lord, we have filed the supplementary affidavit, which is on record, and we brought that supplement. I mean this subsequent assessment order on record, and we have stated, and our objections that was also on the record, and we have annexed with the plain writ applications. And the present, this judgment of the Honorable Supreme Court, it was passed on
fresh assessment by whom?
Fresh assessment by the Calcutta collector.
Where?
Malad, in the supplementary affidavit.
Which page?
At page 6 of the supplementary affidavit.
Page 6.
Page 6 of the supplementary affidavit.
Yes. Page 6, yes.
Annexure B, Malad. Supplementary.
So the
It is the-
stamp duty and registration fees which you had paid in respect of the conveyance, that has been deducted. So they have not paid.
Huh? Pay for registration rates. Portion, that portions has been paid.
That has been deducted.
Deducted.
And the stamp has been toned down.
And therefore, a fresh assessment order has been passed on 16th July 2025 by saying that therefore the stamp duty on the conveyance of the said property amount.
So your objection is if the property itself is not partible and has not been partitioned by dint of this decree, then in that case the decree cannot be treated as an instrument of partition and therefore it is not exigible to stamp.
Correct, correct.
That's your
That's
objection.
my.
And what about this?
Malad, the judgment. Malad,
Anything else, or this is the only point?
This is the only one.
And next point?
Malad, the judgment, it is felt from his lordship's, Malad, it is completely supports us according to my appreciation. Malad, the paragraph 13, if your lordship kindly consider, of the judgment.
Yes.
It is a Justice R. Mahadevan judgments. It is passed on December 20, 2024. Well, in respect of the issue relating to payment of stamp duty for mutation of the subject land, it is specific plea of the appellant that the consent decree or decrees are not chargeable with the stamp duty under the Indian Stamp Act, etc., as applicable to the state of Madhya Pradesh, Section 3 of the Indian Stamp Act, etc., plus Section 3 has been quoted over here. Next, my lord, page 18. This is the main paragraph. From the above, last page. From
page
the
18, 1-8.
1-8.
Yes.
1-8. Last paragraph 13. Paragraph 13. Paragraph 30, the paragraph from the above.
Page 21 of the text.
Page 21.
Oh, I am sorry. I am referring to my SCC
Page
on
21.
Page 20.
From the above, it is a paragraph.
From the above, last paragraph. From the above, it is apparent that stamp duty is not chargeable on an order oblique decree of the court, as the same do not fall within the documents mentioned in Schedule 1 or 1A read with Section 3 of this Indian Stamp Act 1899. Though the collector of stamp determined the stamp duty for the subject land as per Article 22 of the Schedule 1A of this Indian Stamp Act so, which states about conveyance. In this case, we have already held that the compromise decree does not fall under the instruments mentioned in schedule and that it only asserts the pre-existing rights.
But your case was not of compromise, or it was a compromise.
My is a final decree in the partition administration suit. And the final decree is not the instrument for partition. And according to Section 215 of the Indian Stamp Act.
So this judgment is primarily, I think, on compromise decrees.
Compromise decree. But the
Although
test,
at one place it says.
But the test
decrees
is
or,
this: if you do
consent
not have
decrees
the existing here, the
Not an absolute proposition that in all cases of stamping there has to be creation or extinguishment of title. In this case, compromise decree, if there is creation of title, then stamp is charged. That is the
here is also the compromise.
No, but paragraph 13. I mean, I don't know what page 20 of this.
Yeah, my argument is twofold. Number one is it is not a partition of instrument of partition, and
in respect of the issue relating to payment of stamp duty for mutation of the subject.
No, after the after Section 3 of the MP Act is quoted,
Ah.
thereafter from the above.
From the above, it is apparent that stamp duty is not chargeable on an order decree of the court.
Yes.
As the same do not fall within the documents mentioned in Schedule 1 or 1. Decree of the court is not as a general statement, it's in the context of a compromise decree, because it, kindly see paragraph 13 starts with consent decree. It refers
Yes,
to
but
the
still,
consent decree.
it is
Now the
it is on the
important
basis of
paragraph
the
is we
it
have
is on-
already
it is on the
had
basis of the interpretation of Section 3.
Yes.
Section 3 instrument chargeable with duty. this section does not contain any provision, any expression like order or decree, which is why the court has said so.
Section 3 has been interpreted.
Yes, section 3 is devoid of any expression like order or decree.
Now, under section 3, West Bengal amendment, it's not West Bengal. West Bengal amendment says.
See what does it say?
Clearly says that the instruments which are mentioned in Schedule 1A, if they're executed in Bengal, stamp shall be charged. That is very clear. If you lot of take note.
Section 3 is stamping along.
And susceptible.
All these A, B, C go. First is not kindly come to section 3.
Yes.
Subject to the provisions of this Act and the exemptions contained in Schedule 1, following instruments shall be chargeable with duty of the amount indicated in that schedule and the proper duty therefore, respectively, that is to say, that ABC is provided. Dr. Kindly now comes to the West Bengal amendment. Because ABC says notwithstanding ABC, what shall be chargeable? So Dr. Kindly come to the West Bengal amendment. May I read?
Yes.
The following proviso shall be added, provided also that except as otherwise expressly provided in this Act and notwithstanding anything contained in clause A, B or C of this section or in Schedule 1, the amount indicated in Schedule 1 capital A to this Act shall, subject to the exemptions contained in that schedule, be the duty chargeable under this Act on the following instrument mentioned in clauses A and BB of this proviso as the proper duty therefore, respectively. Double A is our case. Every instrument mentioned in Schedule 1 capital A as chargeable with duty under that schedule, which not having been previously executed by any person, is executed in Bengal on or after the 1st day of April 1920.
And Schedule 1A contains decree.
1A contains NP 45 partition D, not D, partition D.
If it is partition, then I have to pay. It is not a partition. My objection
So
is
what is your answer to this?
This is clearly a case of partition.
my objection
Once
has
it
been
finishes,
dealt with. My objection has been dealt with. My objection is at page 98 of your lordship's brief in the main read petition.
Page
It is-
98.
Yes, it is before the collector. It starts from page 97. and
Yes, where has it been dealt with?
Lordship,
Where has that been dealt with? You said your objection has been dealt with. Where?
my lord, in the order of the assessment, my lord.
Where is that order?
My lord, okay. No, not origin. My lord, may I tell you? Assessment order of 13th March 2025. I'm sorry.
Not an X.
Yes. At page 14, first annexure. First annexure, page 13. It
Page-
starts from
Page 14. Okay.
page 14. The case is taken up today. The learned advocate on behalf of the defendant number 3 appeared today and filed Hazira, scene, etc., etc. And he submitted a copy of the order of the Honorable High Court and requested to consider the assessment by considering section 2, subsection 15 of the Indian Stamp Act 1899. Gone through the file, the order of the Honorable High Court submitted subsequently accorded sanctity to the shares of the ownership generated from the sued property and deed of conveyance. Such shares, whether divisible or indivisible, originated from the mother unit, has been taken into account following the decree only dated 29th November 2020, which attracts the provisions of Article 45 at and Article 23 of the Schedule 1A and of the Indian Stamp Act. My lord, there, my lord, 25 and 23 both were levied, my lord. And in the original assessment order. Thereafter, when we filed the REIT applications, they deducted the 23 and come down to 45, Article 45. My objections is solely on that basis that it is not particle.
Very well.
And
got it. Yes, Mr. Ben.
Before going to
That's
the
all.
partition, before going to the
That's all.
partition decree, will not kindly allow me to place the two provisions, then I'll come back to the decree to show that it is a partition. In effect. It will also kindly come to 2 subsection 15 of the Act. 215 has been argued before the collector also. Instrument of partition.
Section 215, yes.
Subsection 15. Instrument of partition means any instrument whereby co-owners of any property divide or agree to divide such property in severalty and includes also a final order for effecting a partition passed by any revenue authority or any civil court and an award by an arbitrator directing a partition. So, not any final order by civil court of partition, effective partition is included in instrument of partition. Now, we will also kindly come to Schedule 1A, entry 45. Entry 45, Schedule 1. There is first Schedule 1, then Schedule 1.
Schedule 1A, entry 45.
45 is instrument of partition as defined by Section 250.
Yes.
1/2% of the market value of the separated share or shares of the property. Now that it has been clarified what is separated share. The largest share remaining after the property is partitioned, or if there are 2 or more shares of equal value and not smaller than any of the other shares, then one of such equal shares shall be deemed to be that from which the other shares are separated. So basically the largest share. If somebody gets 50% or 60%, somebody gets 40%, then the largest share on that it shall be charged. Several instances have been given, but this is how it is to be charged. So, section 215 read with Schedule 1A entry 45 and definition and section 3 West Bengal Amendment. These are the provisions. Now, this is the contention of my senior friend that since the plaintiff has sold his share, plaintiff had 12.5% share, transferred to different number 2.
Plaintiff have 25%.
So, there is no partition which is in fact accorded by the.
No. It is not his contention. His contention is that in terms of the structural engineer's report, the property is not partible at all. So if the property is not partible, no partition can be effected. If no partition can be effected on the basis of the decree, then that decree on the basis of which no partition can be effected cannot be treated to be an instrument within the meaning of this 40.
That is the submission. That is the submission. But paragraph 5 is not the entire order. I'll place the subsequent part below. What happened here? Plaintiff transferred his share to the defendant number 2. Plaintiff transferred, sold, no share left. But among the defendants, the partition has taken place. Lordship will kindly see me, Lord. Because in a partition suit, not everybody is a plaintiff, everybody is a defendant. The decree, if it affects between the defendants' interest, say that is also coming under 250. So kindly come to me, Lord.
That the existing shares has been declared.
Kindly come to Lord 2. Paragraph 5 has been placed. Paragraph 5 is that building at no alteration. It says structural engineer has filed his report wherein it is mentioned that no major addition or alteration in the building at present could be carried out. Since the premises cannot bear the impact of fresh construction to effect the partition as per plan, prepared in consultation with the parties, partition of the premises among the plaintiffs and the defendants in proportion to their shares are not possible. Then kindly what happened? Then shares are transferred. Then kindly come to page 4 of the judgment. On 5th August 2020, para 8. 5th August 2020, the plaintiffs have executed a deed of conveyance in favor of the defendant number 3 with respect of undivided 1/4 share measuring 1323 square feet on account of structure.
In
and
this respect, payment has been made.
In this respect, payment has been made. So there were 2 + 23 that has been written off. But 45 remained in the order.
Only partition remains.
Only 45. This fine. Now, on account of structure and undivided proportionate of the land measuring 620 square feet attributable to the said structure, premises number so and so, the deed of conveyance is duly registered before the additional register of assurance. As the plaintiffs have relinquished their share over the food property by executing a conveyance deed in favor of the defendant number 3, and now the defendant number 3 is entitled to get his share, that is 12.5%, along with the share of the plaintiffs, as mentioned in the conveyance deed dated 5th August 2023. Defendant number 3 has submitted the copy of the conveyance deed dated 5th August 2023. Parties have accepted the plan for proposed partition submitted by the partition commissioner, which is marked as Annexure L to the report of the commissioner and the conveyance deed dated 5th August. A plan for partition was submitted, in which the plaintiff's share has been transferred. So partition plan is there. So far as the defendant's part is concerned, that remains. Only so far as plaintiff's part it said that paragraph 5 said impartible. In view of the above, the final decree is passed by declaring that the defendant number 3 is entitled to get 12.5% of his share along with the shares of the plaintiffs, as mentioned in the deed of conveyance dated 5th August 2023, and defendant number 2 and 4 are entitled to get 37.5% and 25% respectively.
Declaration of share.
Then CS number 91 of 2013 is thus disposed of. Consequently, GA 10 of 21 is also disposed of. Decree be drawn by making the proposed plan for partition being Annexure L of the commissioner's report and the deed of conveyance as part of the deed. So as per the partition plan, Annexure L, making it part of the decree and accepting the partition plan, decree is drawn up. On the last occasion when the matter was taken up, I submitted that they have not annexed the plan. Now they have, then the supplementary was filed, annexing the order of reassessment, and possibly this is the partition plan. Here there are lots. Lot A, kindly see the plan.
Partition was planned for partition were filed, and thereafter structural engineer opined, and this plan cannot be affected.
After page 22 the plan is annexed.
Page 22 of the supplementary.
Of the supplementary.
Yes.
Now Lordship will see A is 25% share, B is 75% share, giving the covered area, and in the map, A and B are separately allotted. In all the floors, respective areas are separately allotted. In the second floor, AB, first floor, AB, and this is the ground floor. Ground floor, A and so what I submit is this, my lord. If your lordship takes this as Annexure L as a part of the decree, so in the decree the shares are separate, A and B.
Shares has been declared. Separate.
Yes.
Shares
What
has
is
been
the
declared. Shares has been
It is not there. I am not interested. What is the partition below? The UAE decree declares the shares, final decree gives them a severability. Now, if this is taken, my lord, the order has to be read as a whole. Maybe if the plaintiff's part is considered, it was impartible. But after the conveyance, if the decree records Annexure L as a part of the decree, and the plan shows separate parts of the separate allotments of the two parties, can it be said that there was no partition affected? So, my lord, if now we go back to the decree, my lord, page paragraph 10 and paragraph 12, I'm once again reading. Parties have accepted the plan for proposed partition submitted by partition commission, which is marked as annexure. How can we say that it is impartible? They are accepting the proposed plan. So far as the plaintiffs, but including the plaintiff, it was possibly not possible. But after the conveyance, paragraph 10 says that the
According
parties are
to you, mere execution of the agreement or sorry, mere execution of the instrument itself will suffice. It may not be physical execution thereof is not necessary.
No, Lord, if this instrument is executed, Lord, this is made a part of the final decree. Final decree is drawn up. Final decree for partition is only not for declaring share. It is for effecting partition. The court is passing a positive final decree of partition.
On the finding that it cannot be partitioned.
That is not the finding in my humble submission.
Yes,
Read paragraph 5.
Because if that is the observation that it cannot be partitioned, and therefore the court, otherwise the court would have appointed a partition commissioner to effect partition.
And partition has been effected. If a lordship sees the final map.
Partition means partition by meets and bounds.
Yes.
That has to happen on dirty ground.
This map is partition. Partition map is the map your lordship has seen. Clearly demarcate separate shares of the party. And paragraph 5, what does paragraph 5 say? I'm reading once more. Structural engineer has filed his report wherein it is mentioned that no major addition or alteration in the building at present would be carried out. Since the premises cannot bear the impact of fresh construction to effect the partition as per the plan prepared in consultation with the parties, partition of the premises among the plaintiffs and the defendants in proportion to their shares are not possible. Among the plaintiffs and defendants, not possible. Now the plaintiff sells of his share. So now it is not between the plaintiffs and defendants. The defendant which has taken place. So you have the
Mr. Banerjee, in a suit for partition, after the preliminary decree, the entire exercise is only to effect partition by meets and bounds. Right. That exercise has not been completed here. Because
final decree has been passed.
But see what is the nature of the final decree.
The commissioner
passed by declaring the shares. Share declaration is done in preliminary decree only. Yes. The hiatus between preliminary decree and final decree of partition is only the execution of the preliminary decree to.
Declaration of share was done by, because after the preliminary decree there was a transfer of share.
Very well. Even if suppose let us assume a situation where this in between transfer is not there. Say there is no conveyance.
Then there would not have been a declaration of share.
Even then, if the situation would have been same, the partition commissioners, not commissioner, this engineer, structural engineer report would have made a part of the report, a part of the decree. Would that then be termed as instrument of partition? Even then,
but if the partition commissioner files a report, that
because this conveyance will not change the nature of the decree. No. The conveyance has only increased somebody's share and decreased somebody's share. This is only so let us for the time being assume that the partition, the preliminary decree of partition, which was passed at the initial point of time, that remains, and that has now matured into a final decree.
Share has changed. Because of the transfer, the shares have changed interstate. Only that has been said.
For the change of shares, this declaration was required. So therefore, that is why I am again coming to it, Mr. Banerjee. If it is only for this conveyance happening that the declaration of shares took place, this would not have been necessary if this conveyance had not been there. Then also would this final decree of partition be treated as an instrument of partition? Because minus the conveyance, it is keeping the same character as that of the preliminary decree at one stage, because partition has physically not been effected.
Now we are kindly see in the partition after preliminary decree what happens. After appointment of commissioner, the commissioner files his report. The report is accepted, final decree is passed. Then also there are cases of execution. If not physically, the commissioner might not be in a position to put the parties in
correct.
Then execution.
Correct.
Commissioner's job is to draw the separate allotment, separate lots, which the court either will accept or not accept. So I say, the entire exercise or
that
endeavor
exercise has been done.
Preliminary decree, then came that is not possible between the plaintiffs and defendant. Then the sale takes place. Then a map.
So according to you, what has not been done is only the execution.
Execution is not done. So that is the physical part. But the moment the decree is not drawn up with not separate lots, that is the commissioner's report which is accepted. This is my humble submission.
That's right. That's true.
That is the problem. what we have learned that preliminary decree, petition commissioner, report, objection to report, acceptance, final decree. That is the order. That has taken place.
He has accepted my submissions.
No. He says, and he has a point in what he's saying. Declaration of shares and demarcation of shares, that has taken place in terms of the structural engineer's report.
No,
It may
not demarcations.
Shares.
Shares has been declared,
Wait,
not
wait.
demarcated. It is
In
as
plan
it is.
it has been.
Plan,
In the
plan
plan it has been. Merely because the building might fall down, that physical partition may not have been possible, but on paper it has been partitioned.
My lord, the paper has been, it has
On
not
paper
been,
it has been partitioned.
we cannot parted this property in the name. It is still an undivided property. Only the shares has been declared since the conveyance has been given.
Cannot be treated as undivided.
Yes, undivided property.
Plan being accepted.
It is undivided property. Mutation has to be done jointly. I cannot say this is 34 and this is 34A, this is 34B, not like that. Unless it is butted and bounded, I have to four things has to be by north this thing, by south this thing.
Very well. Let us meet tomorrow again, because tomorrow it will be possible. Tomorrow, please. Yes.
Lord, serial number 9, matter where I've challenged the non-grant of refund. My other friend said he has some instructions from the department.
I have to have instructions. I need some time. So I will keep it up for 2 weeks. I shall come back to you.
How much time will already gone
Because
by?
he has come from Dubai. So I would request your lordship to keep you up for 2 weeks. I shall come back with positive instructions. If he can come back with instructions, then it can be sorted out on that.
Be sorted out. Just that if that instruction will come a little sooner.
Order record করে নিন, এইটাতে আগে করে নিন. Let this be completed then. Item 1. Heard, Mr. Your book, Mr. Number 9. এই 9 এর ইয়েটা দিন একটু, ফাইলটা। Lords, লিখেন, not required. He'll take time. I'm just recording that.
Right. Maybe get next week, Lord. I think to get instruction 1 week may be enough. Because then, Lord, again the
Without instruction, they cannot help.
actually department.
The writ petitioner seeks issuance of a writ of mandamus